Hello, everyone, and welcome to Uncivil Law. I hope you are having a great day as always. And we are here with the Supreme Court's announcement in the case of Ramos versus Louisiana, a case dealing with non-unanimous jury verdicts in criminal convictions. The state of Louisiana and the state of Oregon have had law that allows them to not have unanimous criminal convictions. You may have seen Law and Order many times that you need a unanimous jury of 12 people, but neither the number 12 nor the unanimity of it has been required. But of course, as to at least one of those aspects is changing. You can still have non-12 member juries, incidentally, and they are often used for lesser crimes for non-12 member juries. But we're not going to get into the number of jurors right now. We're going to get into what vote do they need? What vote do they need to convict? Well, as we're going to discover, the state of Louisiana and the state of Oregon had said not 12, some other number will be fine. And the Supreme Court has said no, not so much. Whatever the number of jurors you have, however many that is, that's how many votes you need to convict. So whether we don't know that's necessarily 12, but whatever number it is, you need all of them. So sorry for the slight delay in starting the stream, but I had to make sure that I understood the preamble from the court because it's a fractured opinion, and some of this is precedent and some of it's not. Because we don't necessarily have 5 votes for everything, although maybe we do. So I'm going to try to determine I know for sure which parts are binding, but I'm not 100% sure which parts are not binding. So I can tell you this section is law. That doesn't necessarily mean other sections are not law, because you have to get into counting. And sometimes you have to do this, and this is one of those occasions. So we're going to give it our best vote. We're going to give it our best, and we're going to say these sections are law, and these other sections might be law. I'm not sure. We'll get into it. All right. Yeah. So we count to 5. So right here was where I knew we were in trouble. The start of the opinion. Justice Gorsuch announces the judgment of the court and delivered the opinion of the court with respect to parts 1, 2A, 3, and 4B1, an opinion with respect to parts 2B, 4B2, and 5, in which Justice Ginsburg, Justice Breyer, and Justice Sotomayor join, and an opinion with respect to 4A, in which Justice Ginsburg and Justice Breyer join. Yay. So, okay. And then we have a preamble, which is none of those parts, so I don't know what this is. Is this unanimous, this part? I honest to God don't know. But this is some musing. So I'm not sure. Is this part unanimous? Is this part like just musings I don't know. Is this all dicta? I have no idea. It's a thing that exists. So we're going to read some stuff that exists that may or may not have any legal operative effect. So we'll see if there's anything that looks like a rule of law in this at all, or if it's just musings. That'll be entertaining. So we're starting with section 0. Which we're not sure who supports this, and we're not sure if it's law. But let's read it anyway. Accused of serious crime, Mr. Ramos insisted on his innocence and invoked his right to a jury trial. Eventually, 10 jurors found the evidence against him persuasive. But a pair of jurors, that would be literally a pair in this case, literally 2, right? It was 10 to 2. But a pair of jurors believed the state of Louisiana had failed to prove guilt beyond a reasonable doubt. They voted to acquit. In 48 states and the federal court, a single juror's vote to acquit is enough to prevent conviction. Normally, it would result in a hung jury. But not in Louisiana. Along with Oregon, Louisiana has long punished people based on 10 to 2 verdicts like that one here. So instead of the mistrial he would have received almost anywhere else, Mr. Ramos was sentenced to life in prison without the possibility of parole. Why do Louisiana and Oregon allow non-unanimous convictions? Though it's hard to say why these laws persist, their origins are clear. Louisiana first endorsed non-unanimous verdicts for serious crimes at a constitutional convention in 1898. According to one committee chairman, the avowed purpose of the convention was to establish the supremacy of the white race. That's super promising language. So if we're looking to, hey, is this racist? Well, apparently in 1898 at the Constitutional Convention, the person who came up with it said, we're doing this to ensure the supremacy of the white race. So might be racist. Yeah, that's a clue. Good times. And the resulting document include many of the trappings of the Jim Crow era: a poll tax, a combined literacy and property ownership test, and a grandfather clause that in practice exempted white residents from most of these requirements. May have something to do with race, yes. Yeah. Nor was it only the prospect of African American voting that concerned the delegates. Just a week before the convention, the U.S. Senate passed a resolution calling for an investigation into whether Louisiana was systematically excluding African Americans from juries. I'm going to go with yes, probably they were. Seeking to avoid unwanted national attention and aware this court would strike down any policy of overt discrimination against African American jurors as a violation of the 14th Amendment, the delegates sought to undermine African American participations on juries in another way. With a careful eye to racial demographics, the convention delegates sculpted a facially racial neutral rule, permitting 10-2 verdicts in order to ensure that African American juror service would be meaningless. Yeah, okay, so again, we're looking to whether or not this might be racist, right? So we know that, for example, blacks compose, about 23% of the population? Something in that order of that magnitude, right? And so we say, okay, on a 12-member jury, how many are there likely to be black? Now, this, of course, assumes that we're coming from a random sample of the population, which we already know we're not because we're already, selecting against other criteria, right? But if we were truly selecting randomly, then if 23% of the members of the jury were black, then you'd expect there to be about, what would that be, 3 members of the jury, right? Okay, but we know that it's not going to be that much because we have other ways to exclude them. So we might have 1 or 2, but that's okay. We have a way to exclude them by just making sure their votes don't count. So it's facially racially neutral. It doesn't on its face apply to race, but if we were looking for the reasons that we're doing it, well, we can just look to what they actually said. We're doing it to maintain the superiority of the white race and to ensure that the black votes don't count on the juror. So, we don't have to go through the laborious exercise of trying to figure out the motives of it because they told us their motives. White supremacy. Super. That's just super wonderful, great. That's all kinds of encouraging. God, Lord have mercy. Adopted in the 1930s, which, for those of you who are unfamiliar with the history of Oregon and some of its race-based issues, Oregon can put the South to the test as to who is more racist. Or Oregon's got some troubled history. Adopted in the 1930s, Oregon's rule permitting non-unanimous verdicts can similarly be traced to the rise of the Ku Klux Klan and efforts to dilute the influence of racial, ethnic, and religious minorities on Oregon juries. Again, we don't have to do a lot of divination to this. We can just look to what they said. Why racism? Why Ku Klux Klan? Oh, okay. Well, that kind of solves that issue. In fact, no one before us contests any of this. Courts in both Louisiana and Oregon have frankly acknowledged that race was a motivating factor in the adoption of their states' respective non-unanimity rules. That's horrifying. It's pretty horrifying. That's pretty horrible. Yeah, okay. And despite this, both states persisted on it for long enough for the U.S. Supreme Court to get involved. That's good news. $20 from Trent Dow for the super chat with no comment. Thank you, Trent, for your support. It helps us grow, as always. We took this case to decide whether the Sixth Amendment right to a jury trial, as incorporated against the states by way of the 14th Amendment, requires a unanimous verdict to convict a defendant of serious offense. Louisiana insists this court that is never definitely passed on the question and urges to find the practice consistent with the Sixth Amendment. Well, I will agree with them, and maybe the Supreme Court will disagree with me, but I would say that Louisiana is right, that the Supreme Court had never definitively ruled on that question. Maybe the Supreme Court will say it had in the past, but at least as far as I'm concerned, the answer, yeah, they had never done it. That's consistent with the Sixth Amendment. No, especially in light of this history, no. I feel bad inside just reading this history. Lord. By contrast, the dissent doesn't try to defend Louisiana's law on 6th or 14th Amendment grounds. Tacitly, it seems to admit the Constitution forbids states from using non-unanimous juries. Yet, unprompted by Louisiana, the dissent suggests our precedent requires us to rule for the state anyway. That doesn't make any sense. The Supreme Court has the ability to overrule its own precedent. It's one of the things the Supreme Court gets to do. right? The Supreme Court is, in fact, not bound by its own precedent. So assuming there is precedent to the contrary, the Supreme Court can overrule its precedent. The Supreme Court can say this is garbage. So, like, the dissent says you're bound by your own precedent. No, not really. I mean, you can just, like, not do that. That not doing that is an option. From time to time, the Supreme Court does overrule precedent. And maybe this would be an occasion to do so. The dissent doesn't seem to think so. Because, the biggest number of votes I counted was 5 for any of these propositions. So at least 4 members appear to think otherwise, at least in part. So I don't know. What explains all this? That'll be good. To answer this question, it's necessary to say a bit more about the merits of the question presented, the relevant precedent, and last, the consequences that follow from saying what we know to be true. Okay, that's cool. Let's go to the merits. Let's talk about the precedent, and let's talk about the consequences. That's cool. I'm down for all this. We will become more educated as a result. The Sixth Amendment promises that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district in wherein the crime shall have been committed, where the district shall have been previously ascertained by the law. The amendment goes on to preserve other rights for criminal defendants, but says nothing about what in a trial by an impartial jury entails. That's fair enough, right? It doesn't say anything about the number of jurors. It doesn't say anything about the vote of the jurors, and doesn't even necessarily say anything about the level of burden of proof they have to raise. We just know it's an impartial jury, but we don't know how many, we don't know what vote, and we don't know what standard they're supposed to read. It doesn't say those things. Now, that doesn't necessarily mean that those things aren't established, because most of the Constitution are talking about pre-existing rights, right? So, like, the freedom of speech is interpreted to be the pre-existing freedom of speech. It's not one that's being created off the cuff, right? So, like, when you're looking to some of the stuff, you look to English common law, you look to English statutory law, right? So, like, the freedom of speech is one that's previously established, right? It's not newly created, right? So, the text of the Constitution just says the right to an impartial jury, right? But it doesn't tell you any of these things. But that doesn't necessarily mean that those things aren't baked in, right? Because freedom of speech doesn't tell you a lot, right? It just says you have a freedom of speech. Well, what does that mean? What are the limits of that, right? But a lot of that stuff is baked in. For example, slander, like is one of the ways to do this is to say that slander is not speech, or it was never encompassed within the freedom of speech. It's not part of the freedom of speech. It was not part of the pre-existing right. So, like, you can view it as either an exception to freedom of speech, or you can view it as just not part of speech at all. Either way gets you there. But, so you could do the same thing in this analysis. What does the impartial jury require? What did the previously established? Fair enough. Isaac, you had 10 whole minutes of notice. So, just teasing, though, just teasing. The amendment goes on to preserve other rights for criminal defense, but says nothing about it. Still, the promise of jury certainly means something. Otherwise, there would have to be no reason to write it down. Fair enough. Nor would it have made any sense to spell out the places from which jurors could be drawn if their powers as jurors could be freely abrogated. Imagine a constitution that allowed a jury trial to mean nothing but a single person rubber-stamping convictions without hearing any evidence, by simultaneously insisting a lone juror come from a specific judicial district previously ascertained by law. Yeah, just because it comes from a judicial district doesn't tell you enough. This random person, if all they're going to do is rubber stamp, it probably is not enough to satisfy this constitutional provision, right? So you can always illustrate your points by going to extreme examples. It's helpful to illustrate points by showing the absurdity of foul to the limit. Like, okay, if it's just an impartial jury drawn from the district, then that presumably would mean one juror. I mean, it could, right? But that's absurd for all the reasons they just said. So it probably doesn't mean that. Illustrating by absurd examples is a reasonable way to legally think. Yeah. And it's not enough. Imagine the Constitution that included the same hall guaranteed twice, not only the Sixth Amendment, but also Article 3. No, the text and structure of the Constitution clearly suggests the term trial by impartial jury carried with it some meaning about the content and requirements of the jury. Fair enough. One of these requirements was unanimity. So they're saying it's baked into the term. It was baked in from square one. Okay, fair enough. Whenever we might look to determine what the term trial by impartial jury, I'm still in the preamble though, so I'm not sure if this has any binding legal effect, or if this is just random musings dicta. I have no idea whether or not this is legally binding. I don't know. I have no clue. One of these requirements was unanimity. Whenever we looked to determine what the term trial by impartial jury meant at the time of Sixth Amendment's adoption, or its common law, state practices in the founding era, or opinions and treatises written soon after, the answer is unmistakable. A jury must reach a unanimous verdict in order to convict. Well, presumably, that is not binding. So presumably, whatever this is, it's not binding legal authority. Because if it were, then we could just, be done. And obviously, there's dissent. So, no. Presumably, this is just random musings by... Who wrote this? Justice Gorsuch. That doesn't particularly have any legal operative effect. So I'm going to say that all this is dicta. That's what I'm going with. It doesn't have legal operative effect. Okay. Did I pass by section 1? Did I pass by the marker? Hold on. Oh, maybe I did. Maybe I am in legal operative effect. Hold on. Maybe he's right. Maybe I did pass by section 1 and didn't notice. Sorry. Yeah. All right. Hold on. Oh, yes, I did pass by section 1. Okay, so it is binding legal authority. Yay. Thank you. Yeah, so we have 5 votes for this. We have 5 votes for this proposition. Okay, great. So this is not dicta. This is actually binding legal authority. Yay. Thank you for noticing. I passed by the section header. All right. So yes, it is binding legal authority that one of the requirements is unanimity. Fantastic. So a jury must reach unanimous verdict. So this is not random musings. This is actual binding legal authority. I know that because I have 5 votes. I counted them. Gorsuch, Breyer, Sotomayor, Ginsburg, and Kavanaugh. I have 5 votes. So we have a split here, actually. So this is not like 5 conservative votes or 5 legal votes. We've got 2 conservatives and 3 liberals. We've got Gorsuch and Kavanaugh from the conservative wing, and we got Breyer, Sotomayor, and Ginsburg from the liberal wing. So this is 5-4, but it's not a traditional 5-4 split. This isn't 5 conservatives or 5 liberals. This is Gorsuch and Kavanaugh, and also Breyer, Sotomayor, and Ginsburg. That's the thing that's happening now, but I can count to 5. I got that going for me. All right, so those 5 people say a unanimous verdict is required. That's binding legal authority. Excellent. Good news. The requirement of a jury unanimity emerged in the 14th century England and was soon accepted as vital right protected by the common law. Yeah. Isaac Wicks knows the irony of saying convictions must be unanimous by a 5-4 split. That's very cute. Yes, right. That is a good ironic point. Very well spotted. Yes, of course this isn't a conviction. This is a legal determination, but still the irony is noted. Thank you, Isaac. As Blackstone explained, no person can be found guilty of a serious crime unless the truth of every accusation should be confirmed by the unanimous suffrage of 12 of his equals and neighbors, indifferently chosen and superior to all suspicion. Good. A verdict taken from 11 was no verdict at all. I will take note here that Blackstone saying that is not consistent with the federal law, because under the federal rules of criminal procedure, it is quite clear that although you're supposed to start with 12 members of a jury, if you ultimately wind up with 11 can make the decision. So, in the federal system, they have alternates and stuff like that, but if you ultimately wind up with 11 jurors, it can be accepted by the court as valid. So Blackstone disagrees with the federal rules of criminal procedure. So take note. The same rule applied in the young American states. 6 constitutional conventions expressly required unanimity. Another 4 preserved the right to a jury trial in much more general terms. But variations don't matter much. Consistent with the common law, state courts appear to regard unanimity as an essential feature of a jury trial. Isaac, I have no insight on why they split by that. I've got nothing. I'm pretty positive that when I predicted the split, I did not predict that split. Yeah. It was against this backdrop that James Madison drafted and states ratified the Sixth Amendment in 1791. By that time, unanimous verdicts had been required for about 400 years. If the term trial by impartial jury carried any meaning at all, it surely included a requirement and long accepted and widely accepted as unanimity. That is totally fair, and that is one of the ways conservatives would typically govern. We look to the way the thing was established, right? It's the pre-existing right to a jury. So it comes with all the things that it meant. And for 400 years, it meant unanimity. And presumably, it should mean that now. So I'm not quite sure where the other conservatives are on this. Maybe we'll read the dissent if we have energy and we'll get into why they think differently. Or if they read the history, maybe they read the history differently. Maybe it's not the way they read the history. But if that's the way you read the history, then normally you would think that that's what it means, right? Okay. But maybe we'll get into why the other conservatives don't think so. Influential post-adoption treaties confirm this understanding. For example, in 1824, Nathan Dane reported as fact, the United States Constitution requires unanimity in criminal juries for serious offenses. I don't know who that is or why his opinion is relevant, but okay. A few years later, Justice Story explained in Commentaries on the Constitution that in common cases, the law not only presumes every man innocent until he's proven guilty, but unanimity in the verdict is indispensable. Well, we know who Justice Story is, right? Similar statements can be found through treatises throughout the 19th century. Nor is this a case where the original public meaning was lost at the time and only recently recovered. Yeah, so there might be like an issue, like if people were unaware of the original meaning, right? But if people were aware of the original meaning, if they had an understanding in their head, then that's what they meant, right? So that makes sense on originalist interpretations. It sounds very originalist so far. The court has repeatedly and over many years recognized the Sixth Amendment requires unanimity. As early as 1898, the court said defendant enjoys a constitutional right to man his liberty should not be taken from him except by joint action of the court and an unanimous verdict of 12 persons. A few decades later, the court established the Sixth Amendment affords a right to trial by jury as understood and applied to common law, including all the essential elements as they were recognized in this country and England when the Constitution was adopted. As the court observed, this includes unanimity, the requirement the verdict should be unanimous. In all, this court has commented on the Sixth Amendment unanimity no fewer than 13 times over 120 years. Well, it sounds like a lot of good precedent, so okay. Sounds like the court has said it should be unanimous a lot of times. That wasn't my understanding of the precedent. Maybe the dissent will get into why that's bad reading of the precedent. Or maybe they think all those times were dicta or something, which I suppose is possible. They could be like random musings and they could say, oh, like all those times are dicta. But like, if you say it like 13 times in dicta, if you're the U.S. Supreme Court, probably means something. I mean, if you say it once as a throwaway, sure. If you say it 13 times in dicta, it's like, may reflect some kind of truth. Yeah. Okay. There can be no question that the Sixth Amendment unanimity requires it apply to state and federal criminal trials. Fair enough. So they're talking about incorporation. That makes sense. The court has long explained the Sixth Amendment is fundamental to the American scheme of justice and incorporates against the states against the 14th Amendment. This court has long explained, too, that incorporated provisions of Bill of Rights bear the same content when asserted in states against the federal government. Yeah, this had been like a long debate in incorporation doctrine. Like, even if it was incorporated, does it mean the same thing against the states as it did the federal government? So this was a whole debate as part of the incorporate. So we're going way deep into history world. But like when they were doing all these many incorporations, because they brought in one clause at a time, very painfully over very long periods of history, right? So as they were doing this, there was a debate. Like, first of all, is it incorporated? And second of all, if it is, does it mean the same thing against the states as the federal government? Maybe it means something different against the federal government. Maybe when it was incorporated, it doesn't mean the same thing. So it was like this whole like alternate version reality possibility thing. And every single time it ever came up, the Supreme Court said, no, it means the same thing against the federal government. They even made this argument as recently as Heller when they were arguing. The DC was arguing the same thing in Heller. In 2008, they were making this argument. Yeah, maybe the Second Amendment is incorporated, but it doesn't mean the same thing against the states. So we can regulate it more in the federal government. They're still making this argument. But no, even in 2008, they were saying no, it's the same thing. So yes, there is one version of this thing against the states and federal government. There's not two different versions of this thing, and thank God for that. I don't want to keep track of all that. $2 from Ricardo Ospinilla. On break from work, take my money. I will happily take your money. Thank you, Ricardo. Okay, now we're in 2A, which still has binding authority. Okay, so we still have the same 5 votes. Gorsuch, Breyer, Sotomayor, Ginsburg, and Kavanaugh for 2A. So we're still in good law. Okay. All right. How, despite these seemingly straightforward principles, have Louisiana and Oregon laws managed to hang on for so long? Good question. It turns out the Sixth Amendment, otherwise simple story, took a strange turn in 1972. That year, the court confronted these states' unconventional schemas for the first time in Apodaca versus Oregon and a companion case, Johnson versus Louisiana. Okay, I vaguely remember this, and I vaguely remember that it was even a more fractured opinion, and even like more disastrous in trying to figure out what the hell the precedent was. I vaguely remember this as an issue, that these opinions, as fractured as this one is, were even more fractured and a total pain in the ass, trying to figure out what the opinion was. So, okay. Ultimately, the court could do no more than issue a badly fractured set of opinions. I vaguely remember that. 4 dissenting justices would not hesitate to strike down the state laws. So 4 said, yeah, they're bad, recognizing the Sixth Amendment requires unanimity as guarantees fully applicable to the states. But 4 justices took a different view. These justices declared the real question before them was whether unanimity serves an important function in contemporary society, which is another way of saying whether or not it's fundamental, or at least that's how I would parse that, right? So maybe they're not saying it's fundamental, but that's the way I parse that. So important function in contemporary society. So say there's an argument about whether it's fundamental. Okay. I mean, I suppose fair. For example, grand juries are not considered fundamental, so they were not incorporated. So, okay, maybe the jury trial is not fundamental. Okay. Fine. So 4 justices apparently thought maybe not so much. Okay, then having reframed the question, well, I don't know that's necessarily reframing the question. It's a valid question, right? Because 4 say they'll strike it down as the guarantee is fully applicable. And then 4 say, no, it's not an important function in contemporary society. Then they say it's reframing. I'll disagree that it's reframing the question. It's asking a different question, but at least it is a valid question. Like whether or not it's a fundamental right. So 4 say, essentially, that it is fundamental and applicable. And 4 apparently say, no, it's not fundamental, which is a valid question. I don't think it's reframing. But, yeah, okay. 4 say it's not fundamental. Fine. We're talking about the past. Yeah. These justices, okay, then having reframed, the plurality wasted few words before concluding that unanimity costs outweigh its benefits in the modern era, so it should not stand in the way. So 4 say, well, it wasn't a fundamental right, so therefore it's not incorporated, which I suppose is a logical conclusion. If you say it's not fundamental, then it wouldn't be incorporated, much like the grand jury clause. Okay, I don't know why. I haven't read that opinion in forever and a day, and I remember it being very, very confusing, and I don't know that I want to go back and read it again. But apparently 4 people thought that jury trials were not fundamental. So let's just take note of that and press on. The 9th member of the court, who presumably would break this tie, the 9th member of the court adopted a position that was neither here nor there. So yeah, we have a 4-4-1 decision. So it's a total legal nightmare. Great. On the one hand, Justice Powell agreed that as a matter of history and precedent, the Sixth Amendment requires unanimity to convict, which sounds pretty promising. But on the other hand, he argued the 14th Amendment does not render this guarantee against the federal government fully applicable against the states, which sounds like he's saying it's not essential. Okay. Which presumably means it's not incorporated? Okay. In this way, Justice Powell doubled down on the belief that dual-track incorporation, the idea a single right can mean 2 different things depending on whether or not it's being voted against the federal state government. Okay, so at least this majority is saying, no, it wasn't an issue of incorporated. They're saying Justice Powell said it was incorporated, but it doesn't mean the same thing. So, okay, so this Supreme Court is saying that Supreme Court said it was essential, but it meant something different. Okay. It's been a long time since I read that decision, so fine. Let's just assume that that's what they said. So the majority is it's incorporated, but it means something different, which is not true for any other guarantee in the Constitution. I'm pretty positive that's correct. I don't think any other decision is that way. I'm pretty sure everything that's been incorporated has been held the same against the federal government as the states. So if it's incorporated, it means the same thing both places. But apparently not this one for reasons. Justice Powell acknowledged, and also he's the only one apparently saying that this is true for dual track reasons. So if I'm interpreting, now I'm doing double levels of parsing. So if I'm interpreting what this Supreme Court is saying about the other Supreme Court, if I'm interpreting what they're saying correctly, they're saying that 4 people said it was essential, 4 people said it was not essential, and 1 person said it's essential, but it only halfway counts. So we don't have 5 votes for any proposition. if I'm interpreting what they're saying about the history. Okay. Wow. This is confusing. Justice Powell acknowledged that his argument for the dual track corporation came late in the day. Late it was. The court had already decided nearly a decade earlier, rejected the notion the 14th Amendment applies to states only a watered-down subjective version of the individual rights. Yes, they had definitely held that. And as I pointed out, even in Heller, the guy who was arguing for the government in Heller was still arguing this idea. So they've tried it every single time. But apparently in the Sixth Amendment jury trial case, it got enough votes to reach a muddled, unclear opinion. So apparently 4 members said, yes, it's incorporated. 4 members said no. And 1 said yes, but kind of only halfway, which means we don't really have a majority for anything. Okay. It's a point we've restated many times too, recently as last year. Yeah, and most notably in Heller. Yeah, there's no double track thing, thank God. Still, Justice Powell frankly explained he was unwilling to follow the court precedent. So, well, he doesn't have to. He's a member of the Supreme Court, right? So he has as much authority to ignore the Supreme Court precedent as anyone. So if he wants to write an opinion saying, yeah, I'd ignore it and do this thing that has been rejected many, many times, yeah, I guess he can. He doesn't have to obey the precedent. He's on the Supreme Court. So he says, I'm unwilling to obey that precedent. He doesn't have to. But, it causes this consternation. Okay. So I offered up the essential 5th vote to uphold the conviction, and based on a view, the 14th Amendment, as he knew it, foreclosed the precedent. That's pretty bizarre, World. Yeah, that's pretty bizarre. So Louisiana and Oregon were allowed to do this because 4 members said it's not essential, and 1 member said it is essential, but it only halfway counts. So that's 5 votes for Louisiana, and Oregon can do what they want. That's pretty confusing. That's pretty confusing. Yeah, I would not be inclined to upheld that precedent. It's either incorporated or not. And if it is, there's one version, like every other opinion has said. We don't do this halfway thing. Okay. In years following the Apodaca decision, both Louisiana and Oregon chose to allow these verdicts, but their practices have always stood on shaky ground. Yes, it does, because it stands on this case that is some sort of bastardized whatever thing that is probably best ignored, and just like pretend it doesn't exist. That would be a good thing. Just like, okay, this case is overruled. Let's pretend it doesn't exist and just figure it out again. Let's just completely ignore the case. It's garbage. Let's just ignore it and just figure it out anyway. I'm good with that. After all, while Justice Powell secured a favorable judgment for the states, it never been clear what rationale could support it in future cases. Only 2 possibilities exist. Either the Sixth Amendment allows for non-unanimous verdicts, or the Sixth Amendment guarantees of a jury trial applies with less force to the states. Yet, as we've seen, both these bear problems. It does bear serious problems, yes. In Apodaca itself, a majority of justices, including Powell, recognize the Sixth Amendment demands unanimity, which would suggest it's essential. Okay, just as our cases are long set. And its court precedents, both then and now, prevent the states court from applying the Sixth Amendment to states in some mutated and diminished form. So Justice Powell was creating all kinds of problems. So what could possibly describe as a holding of Apodaca? Apparently the holding, as I would interpret it, the holding is, yes, it applies, but only part of the way, which I consider to be a garbage holding, and I had to reject it. So, that sounds like the holding. Yes, it applies, because I'm trying to count votes. So, what is the narrowest ground in which 5 people agree, right? Because that's what you do when you have to count votes in a fractured opinion, or at least what you're supposed to do, and at least all kinds of problems. So here's how I'd count it, right? What's 5 votes and what's the narrowest holding that they all agree on? Well, there are 5 votes that say the Sixth Amendment requires unanimity. Okay, great. There's 5 votes that the Sixth Amendment applies. Great. And there's 4 votes that say it applies all the way, and 1 vote that says it only kind of applies. Well, what's the narrowest common ground? What's the least common denominator? That only kind of applies part of the way. So therefore, there are 5 votes for the proposition it applies. To federal juries, it requires unanimity, but to states' juries, not so much. That's how I count to 5. I think it's garbage and I ignore it, but that's how I got to 5. Hurts my brain. Really, no one has found a way to make sense of it. Yeah, because the conclusion that you've reached in counting this is that it means the Sixth Amendment only kind of applies, which is in conflict with like every other incorporation case, like all of them. So either this case is sitting outside the entire rest of the incorporation framework, or it's garbage. I'm going to go with it's garbage. That makes it less hard. I mean, I guess it's hypothetically possible it could sit outside the entire rest of the framework, but you'd want to have a really, really good reason for it to sit outside the entire rest of the framework, right? You can have exceptions. So, like, can this be an exception? Sure. But what's the really, really, really good reason for there to be an exception? Like, what is the master level rationale that you can look at this and be like, oh, okay, that makes sense. There isn't one. It doesn't really work. So it's just easier to say, oh, the opinion's garbage. Let's ignore it. Let's overrule it. Yeah. In later cases, the court has stated Apodaca an exception, unusual, and non-endorsement. At the same time, we've continued to recognize the historical needs for unanimity. We've been studiously ambiguous, even inconsistent, about what Apodaca might mean. Well, that's if you go to like Justice O'Connor and what she said in Casey versus Planned Parenthood, like, one of the reasons to overturn precedent is it's proven unworkable or it's proven unmanageable. So, like, I'll just go cite what Justice O'Connor said in Casey versus Planned Parenthood, say that this is proven to be completely unworkable, and also one of the other separate rationales is if like the precedent or the subsequent case law undermines it, right? So basically, if you keep making exception after exception after exception to the point that undermines the rules, if the exceptions come to the point that undermines the rule, then the rule sucks. So, like, you have two reasons from Justice O'Connor. One, it's proven unworkable, and second, the subsequent case law has made so many exceptions that the rule itself is now so Swiss cheese that there's no rule at all. So if I'm following Justice O'Connor's guidance, I have two independent reasons to overturn this decision. So let's just overturn it. To his credit, Louisiana acknowledges the problem. It is a big problem. The state expressly tells us it's not asking the court to adopt its solo opinion, its precedential force. Okay. Well, I mean, again, the way I would count would say Justice Powell's opinion is the precedential opinion. Because the way you do this is you look for the least common denominator. So, like, yeah, the only justice that signed on to Justice Powell's opinion is Justice Powell. So it's an opinion of one, but it's the least common denominator. It's the one on the narrowest grounds everyone agrees on. So even though it's an opinion of one, it is the least common denominator. So I'd say it is the precedential opinion, even though it only has one justice supporting it, because it's the least common ground. Because there's another case, and I don't remember the name of the case, but there's another case that tells me this is how I'm supposed to deal with piecemeal opinions where there's a lot of fractured votes. So there is a case that says the way I'm supposed to do this is look for the least common denominator. So I'm supposed to count to 5 votes using the narrowest common ground, right? So I'm like not just inventing that off the top of my head. There's a case that tells me to do that. So I was like, okay, what's the least common ground? Justice Powell's opinion, because it's the one that they most agree on, right? It says, yes, it's essential, and yes, it applies to states, but only kinda. The other 4 justices would say not only kinda, but all the way. But they would all agree on kinda. So it's the least common ground, at least the way I would count this. But that tells me it's a garbage opinion. And let's just overrule it. Why worry about it? That's okay, that's fine. Marx v. United States, thank you. Yeah, that sounds right. Marx v. United States, that does sound right. Thank you, Matt, for telling me. Yeah. So Marx is the case that tells me how to count when I have fractured opinions, like the one I have right now. Because I have some with only 4 members, but Justice Thomas also separately concurs, which means Justice Thomas may or may not be agreeing with some of these other ones. So like for Section 2B, which we're about to start, right? I only have 4 votes. So is Section 2B good law or not? Well, I don't know. Yeah, because Justice Thomas also wrote a separate concurring. So Justice Thomas may or may not be agreeing with parts of 2B. So parts of it may or may not be good law. Hurts my brain. The state expressly tells us not asking to accord its sole opinion. Instead, the effort to win today's case embraces the idea that everything is up for grabs, which I suppose is just as equally valid, because if Apodaca is crap and doesn't apply, and we can all agree it's garbage, then everything is up for grabs. I'm comfortable with that. It's just like, once you put everything up for grabs, I have to like do something that's like consistent with everything else, or come up with a really good reason not to make it consistent. So, okay. It contends this court has never definitively ruled on it. Oh, this is part 3B. At some point I get into 3B, so this part is not good law. Okay, so this part is just musings. At some point I crossed into 2B. I wish the headings were, so, okay, so this part is not good law. So this whole stuff is just random musings. Maybe, possibly. I'm not sure, because Justice Thomas may or may not be agreeing with this. So we got 4 votes for the opinion that Apodaca is kind of crap. So is Apodaca still good law? I honestly don't know. I presumably not. Presumably it's being overruled, but only 4 justices agree on this much. My brain hurts. And we should use this case to hold for the first time non-unanimous juries are permissible in state and federal courts alike. Okay, well, there were some random musings from 4 justices, which may be good law or may not. Because I only have 4, but then I have Justice Thomas separately concurring. So then, like, if I go to Marx and use that as a rationale, I might be able to get Justice Thomas's vote in here or not. So it might be good law. I don't know. Okay. Then we've got part 3, which is definitely good law, because I definitely have 5 votes for that. Oh, my God. All right, this is one of the more complicated ones we've done together on Supreme Court React. This is what happens when you have fractured votes. You have to read it and you have to like figure out, wait, what's good law and what's not. This is tough. This is hard. So, I know Section 3 is good law because I've got 5 votes for that. So that's good news. Louisiana's approach might not be as tough as trying to defend the dual track theory of incorporation, but it's pretty close. How does the state deal with the fact this court has said 13 times over 120 years the Sixth Amendment does require unanimity, or in fact the 5 justices in Apodaca said the same? The best state can offer is to suggest all these statements came in dicta, which okay, it's not a wholly unreasonable argument. Because my understanding was that there was no precedent that said explicitly this. So if there are 13 cases that have a line that says this, right, then it would be reasonable to say, or at least off the top of my head, like, how would you square that? How would you say it said 13 times, but it's not binding? Say all 13 times are dicta, so it doesn't really count? Okay, that's a reasonable argument. My counter to that is, but 13 times though, right? If the Supreme Court said it once or twice or 3 times, like maybe it's just random musings, but they said it 13 times over 120 years, may reflect something a little bit more than dicta. So it strikes me as a little bit different than, it's just a throwaway in one case and doesn't really count. It's a throwaway in 13 different cases. That's a tough road to hoe, man. But even supposing, without granting that Louisiana is right and it's dicta all the way down, which, rough, why would the court now walk away from its many own statements about the Constitution's meaning? Good question. Even if it was random musings we did a whole bunch of times, why would we walk away from that? That's a good question. And what about the 400 years of case law requiring unanimity? Should we dismiss all those as dicta too? Yeah, should we dismiss 400 years of case law as dicta? That's a lot. Sensibly, Louisiana does not dispute the common law required unanimity. Okay, this is going to be good. I can already tell. I can already tell. I honestly, God, haven't read ahead, but I already know what's coming. Louisiana's going to argue the Sixth Amendment, when it was written, did not adopt the common law interpretation. Good luck with that plan. Good luck with that plan. How do I only have 5 votes for this? This sounds like Louisiana is about to argue some bullshit. How do I only have 5 votes to say, yeah, this is bullshit? Jesus Lord, where are the other people? All right. Sell me some bullshit, Louisiana. Tell me why the Sixth Amendment doesn't adopt the common law meaning. Okay, this is going to be good. Instead, it argues the drafting history of the Sixth Amendment reveals an intent behind the framers to leave this particular feature behind. Okay. What? I mean, I suppose it's possible, but you'd expect it to be a little bit more explicit. All right. The state points to the fact that Madison's proposal for 6th Amendment originally read, yeah, there were many, many different drafts. That's fine. The trial for all crimes shall be by an impartial jury of freeholders of the vicinage with requirement of unanimity for conviction of the right of challenge and other accustomed requisites. Okay, so yeah, originally it said unanimity and then they dropped it out. That doesn't necessarily mean that they didn't want unanimity. I mean, it can be suggestive of that, or it can also be suggestive that unanimity is so clear that we don't need to say it, which was the case for a lot of things, where it's like, oh, they drop things out because of course it's understood. So Louisiana's reaching, man. They're reaching hard. They're saying, oh, the original draft said unanimous, and then they dropped it. That means they didn't want to adopt it. No, probably not. Louisiana notes the House of Representatives approved this text with minor modifications, yet the state stresses the Senate replaced impartial jury of freeholders of vicinage. What the hell does that word even mean, by the way? I don't even know how to pronounce it. What does that word mean? Vicinage. What does that word mean? I have to look it up. Hold on. I have to look up what that word means. Vicinage. No, I'm misspelling it too. Vicinage. Vicinage. Definition. Another term for vicinity. A neighborhood or surrounding district. Okay, so it just means like from the neighborhood, which, you know, is kind of reflected in the text now. Okay, it just means from the neighborhood, from the vicinity. Okay, great. I'm on board. Fine. All right. Yeah, the state stresses the Senate replaced impartial jury of freeholders, which means landowners, of the area. Okay, with impartial jury of the state and district where the crime shall be committed, which is a little bit more defined, right? From the area is a little bit less defined. From the district is a little bit more defined. I'm good. And also remove the express limits to unanimity, the right of challenge, and other accustomed requisites. In light of these revisions, Louisiana would have us infer an intent to abandon the common law tradition. Just no. Just no. That's not what you would do, right? You're saying something explicit, but it was already implicit. So why say it explicitly? Like, if you want to abandon it, you can do it explicitly, but this by making the language a little tighter, no. How do we only have 5 votes for this? Where are my other votes, man? This is okay. But the snippet of drafting history could just as easily be to support the opposite. Yeah, I would read it that way. Maybe it's sent to lead the language about unanimity, the right to challenge, and other requisites because it was also plainly included in the promise. That's the way I'd interpret it, right? It's like so basic, we don't need to say it. Yeah, yeah. And the Senate considered it surplus. Yeah, that's what I'd be going with. The truth is, we have little contemporaneous evidence shedding light on why the Senate acted the way it did. So rather than dwelling on the text left on the cutting room floor, we are much better served by interpreting the language Congress retained and the states ratified. That's fair. So we don't know why they did it. They drafted it, but let's just look at the language they actually adopted and what does that actually mean? What does it understand it to mean at the time? This is what a conservative would normally do, right? It just looks at the language at the time. So like other language they considered is kind of a little bit informative, but like, what did they actually just adopt? And what did it mean? If the common law was juries had to be unanimous, then unless they said otherwise, I consider it to be like, yeah, that it's just surplus seems the better interpretation. How do we only have 5 votes for this? I don't know. Zachariah asks, is this an example of judicial activism since it's never explicitly stated or established and no one bothered ever writing it? I mean, for me, no. I don't consider it judicial activism. Judicial activism for me would be like creating a law. That would be creating a law. This is not creating a law. This is trying to interpret law, is the distinction for me. So we have a term that the Senate adopted, and we're looking to other things to try to interpret it, right? So we can look to context. We can look to a whole bunch of things. So, like, for me, none of this is judicial activism. This is trying to figure out, what did the language mean? What did Congress mean when it wrote this language? And for me, operatively, it's what did it mean at the time? What did it mean in 1791? What was the understanding of that language? Now, I don't think it's invalid to look to other languages that they considered as being informative, but, again, I would assume that if you say, like, the right to a jury trial, you mean the pre-existing right, which all the things that come with it, the one that is established at common law, right? Because we're adopting all that stuff from England. It's a pre-existing right. Same as freedom of speech. The freedom of speech. It's a pre-existing right. The jury trial. It's a pre-existing right. We're not creating it. We're simply adopting it, right? So it's something that existed before. We're simply just creating it. Or adopting it. Apologies, not creating it. So, like, without more, I assume that you mean, like, the one that existed. And so the Constitution talks about the jury trial. I assume that means the jury trial. And you say, well, they explicitly said a whole bunch of stuff and then took it out. I'm like, okay, but that doesn't tell me anything. It doesn't tell me that they didn't want it, because all that stuff was part of the pre-existing right. So maybe they just excluded it because it was repetitive, which, for me it is, because it's established. So why say it explicitly? It's just better drafting to not have it, because why say something that's implied? So no, I don't think it's judicial activism, no. It'd be judicial activism if we're creating something from nothing, but that's not what's going on, at least to me. I just don't understand why there's not more than 5 votes for it, because to me this seems like pretty obvious. Okay, let me rephrase that. Let me rephrase that hard. It's not obvious, because I think that there's a lot of issues to struggle with. And so it's something you have to struggle through. So I don't mind that, like, it's something you had to actually work through. I just think, like, in the end, it's the right conclusion. And I'm not quite sure where my other members of my court is right now. As we see, the right to a jury meant a jury that renders unanimous, right? So we adopted the common law. The Constitution adopts the common law. It adopts the common meaning. These are commonly understood things. The First Amendment reflects the freedom of speech. It's the common law freedom of speech. Well, what is that? Well, we looked at English common law. We looked at Bill of Rights. We looked at all kinds of the English Bill of Rights. When I said Bill of Rights, we looked at the English Bill of Rights. We looked at English law. We looked at the long established common law. We've been doing this since 1066. We got a lot of law, so we can look to all that stuff. Yeah. Further undermining Louise's inference about the drafting history is the fact it proves too much. As since deletion of unanimity changed the meaning of text, the same word would seemingly have to follow other deleted words. So it's not just unanimity, but all the other custom requisites, everything that history might have taught us. That's a fair point. If it's good for one, it's good for everything. And, like, that would mean, like, everything goes to hell. Yeah, Taking the state's argument from drafting history to its logical conclusion would thus mean the right to trial by jury devoid of meaning. Yeah, a little bit. A right twice mentioned in the Constitution would be rendered empty, and that can't be right. Yeah, so, like, it does prove too much, right? If unanimity got dropped, then all the other stuff got dropped too. And then what's left of the right to a jury trial? It's empty in the literal sense. It doesn't have any meaning. Like, words in the Constitution presumably have some meaning. At this point, I'd like to remind the U.S. Supreme Court that there's the Privilege and Immunities Clause is a thing that exists, and anytime they'd like to undo the slaughterhouse cases would be just fine. But it has some kind of meaning. It can't be empty. How do I only have 5 votes for this? This is weird, man. How do I only have 5 votes for this? If the history is this way, it seems well in line with the originalist understanding. It seems well in line with textualism, right? What did the black and white text mean? It mean exactly this. It's like, okay, this seems originalist. This seems textualist. Where are my other conservatives at? We're probably going to have to try to get into dissent to try to understand if there's an alternate. If I understand, it's like, am I missing something? Am I missing something in terms of originalism understanding, or are my other decisions non-originalist? So maybe the history is not this clear. Maybe the other people think that the originalist understanding really should go the other way. If that's the opinion, then I'll be very interested to read it. If there's an originalist understanding that goes the other way, I'd be thrilled. If they're going to be non-originalist, I'm going to be salty. Let's figure out which of those it is, right? Faced with this hard fact, Louisiana's only remaining option is an advice to distinguish between the historic features of common law jury trials we think serve as important enough to migrate silently in the Sixth Amendment and those that don't. Yeah, silent but it's there. And then on the state's account, we should conclude unanimity is not worthy enough to make the trip. Tough argument, man. Tough argument and crap. And why do I only have 5 votes to say it's crap? But we see dangers of Louisiana's otherwise approach. There's no need to look further than Apodaca itself. Therefore, justices pursuing the functionalist approach Louisiana espouses began describing the essential benefit as the interposition of common sense judgment of a group of laymen between the defendant and the possibility of overzealous prosecutor. And measured against that muddy yardstick, they quickly conclude that requiring 12 rather than 10 votes to convict offers no meaningful improvement. Meanwhile, these justices argue that states have good important reasons for dispensing with unanimity, such as seeking to reduce the rate of hung juries. Who can profess confidence in a breezy cost-benefit analysis like that? It's a little breezy. It's a little thin. It's a little bit thin to do what you're trying to do, right? If you want to do this, it's a little bit thin. Lost in the accounting are the radically discriminatory reasons. That too. If you needed another motivation to strike it down, on top of originalism, racism is also a good reason. So I personally don't need that reason because the originalism tells me I should be adopting this. But if I need another reason, that it was racist is a pretty good additional reason. So, Justice Mueller didn't need this additional reason, but it certainly helps. What's more, the plurality never explains why the promised benefit of abandoning unanimity, reducing the rate of hung juries, always scores as a credit, not a cost. That's fair. There are costs to that. Presumably innocent people going to jail. That's a cost. But who can say whether any particular hung jury is a waste, rather than an example of a jury doing what the plurality says it should, deliberately and carefully safeguarding against overzealous? Yeah. How do you know that the hung jury is a waste, rather than doing exactly what they're supposed to do? Good question. And what about the fact, too, that some studies have suggested the elimination of unanimity has only a small effect on the rate of hung juries, or the fact that others profess to have found requiring unanimity may provide other benefits, such as including more open-minded and thorough discussions? It seems that Apodaca's plurality never even conceived of possibilities. I don't know why I'm bound to Apodaca. Why do I care? I'm the U.S. Supreme Court. It's a crap opinion. Let's just ignore it and move on. Our real objection here isn't that Apodaca's plurality cost benefit was too skimpy. Yeah, that is not my real objection too either. Yeah, that's not my real objection too. I'm just musing as an aside. Yeah, that's not the problem. The deeper problem is the plurality subjected the ancient guarantee of a unanimous jury verdict of its own functionality assessment in the first place. Yeah, no, you can't do that. The functionality assessment was done for you when it was adopted. Also see, slaughterhouse cases. Anytime you want to overturn them will be just fine. And Louisiana asks us to repeat the error today, just replacing Apodaca's functionalist assessment with her own updated version. All this overlooks the fact that at the time of the Sixth Amendment's adoption, the right to a jury trial included the unanimous verdict. When the American people chose to enshrine that right, they weren't suggesting fruitful topics for future analysis. I love that line. This is really good shit right here. I like this line. This line I like quite a lot. This line I like quite a lot. When the American people chose to enshrine the right in the Constitution, they weren't suggesting fruitful topics for future analysis. I like that line quite a lot. They weren't suggesting, hey, here's some topics that you might want to discuss in the future. No, that wasn't what was going on. They were saying, hey, we have done the cost-benefit analysis. These are the conclusions we have reached. This is now the reality. I like this line quite a lot. It appeals to my snark. I'm reading this with snark. This appeals to me quite a lot, yes. They were not suggesting here's some topics for further discussion. No. Yeah, that line I like quite a lot. They're seeking to ensure that their children's children would enjoy the same liberty that they had won. Yes. As judges, it's not our role to reassess this. Yeah, it is not our role to reassess the calculation. That's not what we do. That would be judicial activism. Yeah, that we're not going to do. The people have made their decision. They have said it is the right decision. It is our job to do their will. With humility, we must accept the right may serve purposes evading our current notice. It's not for us to figure it out. We are entrusted to preserve and protect liberty, not bounce it away by no means that's social statistics. Yeah, this is some badass stuff right here. I'm like, yep. Yeah, it is not our role as judges to figure out whether or not this is a good idea. It's not our role to figure out whether or not the balance should be somewhere else. It's not our role to take notice of statistics or any of that crap. No, that's not our job. It's not our job. The people that enshrined it in the Constitution or statute or regulation, as the case may be, at least as far as I'm concerned, have already made that calculation for us. It's not our job to figure it out. Our job is simply to do what the rules require. And the Constitution requires it. It's not our job to figure out whether or not unanimous jury trials are a good idea or not, or whether it's worth it or not. Not our role. Not our ball. Someone else figured it out for us. They told us. They dictated it to us in black and white. It is now our obligation to do that thing. I could not agree more. This is pretty much on point with what I say. Yeah, this is Gorsuch writing. All right, so now we're in 4A, which only has 3 votes, which means that it's not unanimous. All right, so this part is not unanimous. We only have 3 votes for this, and I don't think I have enough votes anywhere to make this unanimous. So I guess this is just, I don't know. I haven't gotten that. We'll get to dissent eventually. We're on page 16 of, I don't even know how many pages are on this thing, of 87. We're going to have to be here a while. I'm going to have to take a bathroom break at some point. Yeah, Dogbert, don't worry. We're nowhere close to finishing. We're going to be here a little bit now. This part is not binding. This part is random musings. These random musings come courtesy of Gorsuch, Ginsburg, and Breyer. If Louisiana's path to affirmance is a difficult one, the dissent is trickier still. The dissent does not dispute the Sixth Amendment protects the right to unanimous jury verdict, or the 14th Amendment extends this right to state court trials, but insists we must affirm the conviction anyway. Why? Because the doctrine of stare decisis commands it. There are 2 independent reasons why this answer falls short. Well, for example, the precedent socks would be a good one. In the first place, and as we've seen, not Louisiana tries to suggest Apodaca supplies a governing precedent. Remember, Justice Powell agreed the Sixth Amendment requires unanimous verdict to convict, so I have no objection to that aspect of our holding today. Justice Powell reached a different result only by relying on a dual-track theory of incorporation the majority of the court has already rejected and continues to reject. And accept that reasoning as precedential, we'd have to embrace a new and dubious proposition. A single justice writing only for himself has authority to bind this court to propositions already rejected. Well, I don't quite... so I probably would not be joining on to this either, to be fair. Like, I don't read it that way. And that's not consistent with the Marx. And Marx is still good law because we don't have anything better. I think Marx is kind of crap, but we don't have anything better to replace it with. So yeah, I probably wouldn't be signing on to this either. Like, yes, I think Justice Powell's opinion probably is the binding one. Because using Marx, it is the opinion that has the narrowest agreement. So, yeah. It is inconsistent with everything else, which is a good reason to overturn it, but it is probably binding precedent. So yeah, I probably wouldn't be signing on to this either. I'd just be saying, yes, it's binding precedent, and by the way, I'm turning it aside, because it's crap. This is not the rule, and for good reason. It would do more than destabilize it on a precedent. To see why, consider a hypothetical. Suppose we face a question of first impression under the Fourth Amendment, where a state must obtain a warrant before reading a citizen's email in the face of an internet provider, using the email as evidence. Well, I'm not sure how first impression-y that is because, we have cases dealing with documents, and presumably it's a document, but there are some other things because it's being held presumably in the hands of another, but whatever. So maybe a third-party doctrine issue. Imagine this question splits the court. Before justice finding the requirement for a warrant and for finding no such requirement, the Ninth Justice agrees the Fourth Amendment requires the warrant, but takes the idiosyncratic view of the consequences of violating that right. In that view, the exclusionary rule has gone too far and should only apply when defendant is prosecuted for a felony. Because the case before it happens to be a misdemeanor, they provide the ninth vote to affirm the conviction. Of course, this has a long-standing requirement, the suppression of all evidence obtained in a search and seizure, MAP. But let Justice Powell, our hypothetical Ninth Justice, sticks to the view and expressly rejects this precedent. Like Powell, the view would be essential to judgment. So as the dissent suggests, that is enough to displace precedent. Would MAP's exclusionary rule now be limited to felony prosecutions? Presumably, yes. In this hypothetical world that you're creating for me, presumably, yes. Presumably, it would be a modification of map. So presumably, yes. The way again, because I'm trying to read this as consistent with Mark, which it deals with how to deal with split precedents. So like, yes, presumably in that hypothetical world, map would now only apply to felonies. So again, I wouldn't be agreeing with this. I don't think I'm a vote for this, because yes, that would be the consequences of that. But yeah, so I don't think I'm on board with this part of the opinion either. Admittedly, this example comes from our imagination. Fair enough, it's a hypothetical, and I'm following the hypothetical through, and I'm like, yes, presumably that would be a repudiation for all misdemeanors, which is a partial repudiation of MAP, which, is something the Supreme Court could do, and apparently that is the least ground. So, yes. But if the court were to embrace the dissent's view of stare decisis, it would not stay imaginary for long. Every occasion which the court is evenly split will present an opportunity for a single justice to overturn precedent to bind future majorities. Fair. Which suggests that we may need to modify Marx rather than modify. So maybe this is not. We should modify MAP so much as we should modify Mark. Because if I follow Marx through, then this would be the reasonable conclusion, which may be a reason to overturn Mark. But then I have to replace it with something, and I don't know how to do that yet. So, yeah, my mind is convoluted in all kinds of directions. I wonder if you guys are as confused as me, because this is like all kinds of stuff, man. This is... Yeah, Mark is a case dealing with how to count votes if there's split opinions. It's an opinion that tells me, it's Marx versus United States. It's a case that tells me how to deal with split opinions. So it's a meta interpretation rule. Marx is a case that says if the court is split, here's how to count them. And presumably following that, I would reach this result. And therefore, and this is telling me, but that's crazy, which means I'd have to modify Marx. So, okay. Yeah. I'm going to need to take a beer and a pee in about 5 seconds. Okay. Every occasion in which this court is evenly split would present an opportunity for single... Okay. Rather than advancing the goals of predictability, such an approach would impair them. Yes, it would. But what does that mean for the future? You see, what this is not telling me, what this is not telling me is what that would mean in the future. Suppose it did happen, then what? Are we saying that opinion isn't valid? I mean, it is. Are we saying it's not precedent? I mean, presumably it is. So I'm not quite sure what Gorsuch is saying, what that means for the future. My brain hurts. The Senate contends in saying this much, we risk defying Marx versus United States. Yes, you would risk defying Marx versus United States. I agree with that. According to Marx, okay, so a lot of you people have been asking, what is Marx? Here's Marx. All right. According to Marx, when a fragmented court decides the case and no single rationale explains the result, enjoys the agreement of the 5 justices, the holding of the court that may be viewed as the position taken by the members who concurred in the judgment on the narrowest grounds, the least common denominator. Yes, that's what Marx says, the least common denominator. But notice that the dissent never actually gets around to telling us which opinion it considers to be the narrowest and controlling one under Marx or why. Presumably, Justice Powell's is the one that is the narrowest. So presumably, Justice Powell's is the guiding opinion as far as Marx is concerned. Because it's the opinion that enjoys the least common denominator, I think. So yes, Justice Powell's opinion controls. And yes, in this hypothetical universe where this 9th justice is saying but MAP doesn't apply to misdemeanors, yes, that would presumably control, because that's what Marx tells me to do. Yeah. I'm going to need many beers. I'm going to need a break. I'm going to get to the end of this opinion. I'm going to get many beers because I need many, many beers. So while the dissent worries about what you define Marx, it's highly coy about exactly what the precedent might find, which is reasonable. For me, I think Justice Powell's opinion is controlling. So don't worry about that. I don't know. I don't know what kind of drink I'm gonna make. I don't know. The parties recognize what the dissent does not. Marx has nothing to do with this case. Okay, that is the least true statement of the entire opinion. That is the least true statement of this opinion. Marx has a credible amount to do with this case. This is the opinion that Marx was written to deal with. Now, Marx itself might be crap, which is totally possible, but this is a fractionated opinion. Marx has quite a lot to do with this case. I'm quite sure. Unlike a Marx dispute where the litigants duel over an opinion represents the narrowest and controlling one, the parties before us accept that Apodaca yields no controlling opinion at all, which I don't think is true, but okay. In particular, both sides admit that Justice Powell's opinion cannot bind us precisely because he relied on dual-track rule of incorporation, that an unblanket rule of opinion before us and after has rejected. Well, both the parties may admit that, but I still think it's controlling, at least as far as Marx. Because what's the alternative? What's the alternative? If Justice Powell's is not the controlling opinion from Apodaca, which maybe it's not the least common denominator. I'm open to being told something else is the least common denominator. I'm open to that. So, like, if you want to tell me something other than Justice Powell's opinion is the controlling opinion under Marx, I'm down for that. But what is it if not his opinion? In particular, both sides admit it cannot bind us precisely because it's relied on dual-track rule of incorporation. Before and after, that doesn't follow to me. Still, dissent presents an issue, suggesting a single justice's opinion cannot overrule prior precedent under the logic of Marx. That would seem to follow under the opinion of Marx. I think that's right. I'm not sure why it should be. I think the dissent probably is right that the single opinion would be binding. Yes. I'm just not sure why I, at this particular point, would care, because I would overrule Apodaca. So yes, if you asked me, I'd say yes, Justice Powell's opinion is controlled. Yes, it basically undermines the Supreme Court's opinion, literally all the other places, which is a good reason as any to overturn it. So yes, I mean, under the logic of Marx, a single justice can overturn like all the other precedent, which is good reason like it should die. So I think I agree with them at dissent on this one. This is good. But as the dissent itself implies, Marx never sought to offer or defend such a rule. It does seem to be the inevitable result of Marx, though. That seems to be the logical conclusion. As we've seen too, a rule like that would do more harm than advanced stare decisis. I don't know what the alternative is, though. I mean, this hypothetical future court that is hypothetically interpreting, the application of MAP onto misdemeanors, if you came up with that vote, presumably that would have to be a valid decision from the U.S. Supreme Court. So Gorsuch apparently is saying this hypothetical future court that reaches a hypothetical future opinion, it's not good law. How does that work? I don't know. It's okay. This is, yeah. I can't agree with this. I don't think. I mean, the fact that Justice Powell's opinion is controlling is a little wackadoo, which again is a reason to overrule it. But I'm okay. The dissent's backup argument fares no better. In the end, even the dissent is forced to conclude that Powell's reasoning lacks controlling force. But you don't look to reasoning, you look to holding. If you think that the reasoning is crap, which it is, the reasoning is crap. The reasoning is absolutely crap. It's absolutely crap. His reasoning is crap. His reasoning is the dual track, though. And that's crap because it's inconsistent with like literally everything else. So his reasoning is total crap. But it's still the holding, which is a good reason to overturn it. Jesus Christ. So far, so good. The dissent suggests Apodaca somehow supplies a controlling precedent as to its result. Yes, that's what I agree. I agree with the dissent. I agree with the dissent. It does provide a controlling precedent. It's just crap controlling precedent. Overrule it. It is crap. It is controlling under Marx. You're not, okay. Jeez. Look closely, though. The dissent acknowledges looks suspiciously like the reasoning of Justice Powell's opinion. Okay. In Apodaca, this means that when a defendant is convicted to state court of at least 10 or 12 convicted, the defendant argues the conviction violates the Constitution because the vote was not unanimous, the challenge fails. Where does this convenient state court qualification come from? Neither from Apodaca plurality nor dissent include any limitation like that. That's true. It doesn't. Neither the plurality nor the dissent say that. That's true. Only Justice Powell said that. But under Marx, it's the least common ground. Right? I mean, that's the way I would interpret Marx. So, under Marx, it is the right rule. It's crap and should be overturned, but yes, it does come from one opinion, but it's the least common ground. That's what Marx tells me to do. If you want to overrule Marx, I'm for that. There was a case last term, and I can't quite remember what case it was, but there was a case last term where people thought that they might be overturning Marx. So there was that Marx is the rule has been like questioned, and not for least the reasons that appellate judges have a really hard time applying Marx. They have a tough time. The appellate courts struggle trying to count to 5. They struggle all the time trying to count to 5. It happens all the time. So there was a case last term where it looked like they might be overturning Marx and it didn't happen. So the fact that we wanted to overturn Marx, I'm on board with. But I don't know what the alternative is. And if we follow it, it does suggest that Powell's opinion is controlling. The opinion turns on the meaning of the six. What the sense characterizes as the result turns out nothing more than Justice Powell's reasoning about dual track interpretation dressed up to look like a logical proof. Justice Powell reached the wrong conclusion. He did the wrong thing, but it is the least common ground. So I think the dissent has the better of it. I'm not sure why I should care. I'm not sure why Apodaca should control. Just overrule it. That's fine. All this does no more than highlight an old truth. It is usually judicial reasoning. It's ratio de decilente that allows it to have life and effect in disposition of further cases. I only have 3 votes for the proposition that it's the reasoning rather than the result that governs. Which, if you ask me, is the reasoning or the result more controlling? I'd actually have to think about it. And I don't want to do that right now because my brain hurts. I'm going to need a very stiff drink after this. As the court has repeatedly explained in the context of summary affirmations, unexplained decisions may settle the issue for parties, but they are not to be read as renunciation by this court of doctrines previously announced in their opinions. Okay, fine. Much as can be said here. The Apodaca court's judgment line resolved the case for parties in that case. It's binding in that sense, but stripped from any reasoning, its judgment alone cannot be read to repudiate this court's repeated pre-teachings on the 6th and 14th Amendments. Okay. Okay, and I'm all right. Okay. We definitely have to keep reading. We are not going to stop. But I need to take a quick break. And I need to make a drink. So, talk amongst yourselves. I will be right back. For those of you who are curious, it is 2 ounces of Tito's vodka, 2 ounces of an espresso liqueur, and 2 ounces of Bailey's Irish cream, topped with a little bit of plain Irish cream, or plain heavy cream. And it's very, very tasty. And it's wonderful. And yes, to someone who asked, this is an IKEA Marcus chair. If you have any suggestions as to alternative chairs I should look at, let me know. I've had the chair for a while and it's fairly comfortable, but if you have alternative suggestions, Selenium, let me know. All right, let us continue. Let's continue as we try to understand this together. This is good stuff. We're in B1. Are we in 4B1? Where the hell are we right now? Yes. We're in 4B1. So this part is binding. This part has 5 votes. So we're in 4B1, right? So this is Gorsuch, Breyer, Sotomayor, Ginsburg, and Kavanaugh. So this part is binding. Okay. Yeah. There's another obstacle the dissent must overcome. Even if we accept the premise that Apodaca established a precedent, no one in this court is prepared to say it was rightly decided. Yeah. And stare decisis isn't supposed to be an art of methodically ignoring what everyone knows to be true. Stare decisis definitely has its limits, so... Of course, the precedent of this court warrant our deep respect as embodying the concerted views of those who have come before, but it's not treated as an inexorable command. I mean, they do overturn a couple decisions every year. It's not like that big a deal. Okay, it's a bit of a deal, but they do every term. And doctrine is at the weakest point when we interpret the Constitution because a mistaken judicial interpretation of the Supreme Clause is often made practically impossible to correct through other means. To balance these considerations when it revisits a precedent, this court has traditionally considered the quality of the decision's reasoning, its consistency with related decisions, legal development since the decision, and reliance on the decision. That is quoting Justice O'Connor, is it not? No, apparently not. Well, it's quoting an opinion called Franchise Tax versus Hyatt, which might be quoting Justice O'Connor, but sounds like the 4-part test from O'Connor. In this case, each factor points in the same direction. Start with the quality of the reasoning. When we look to the plurality opinion or Justice Powell's separate concurring, Apodaca was gravely mistaken. Again, no member of this court today defends it as rightly decided. Without repeating what we've already explained in detail, it's just an impractical fact. The plurality spent almost no time grappling with the historical meaning of the Sixth Amendment jury trial right. This court's long repeated statements that demands unanimity or racist origins of the law. Instead, the plurality subjected the constitutional jury trial right to an incomplete functionalist analysis of its own creation, for which it spared one paragraph. Wonderful. And of course, 5 justices expressly rejected the plurality's conclusion the Sixth Amendment does not require unanimity. Meanwhile, Justice Powell refused to follow this court's incorporation precedent. 9 justices recognized this for what it is. 8 called it error. Looking at Apodaca's consistency with related decisions and legal development compounds the reasons for concerns. It's as uneasy with 120 years of preceding case law. Given how unmoored it was at the start, it might seem unlikely that later developments could have done more to undermine the decision. Yet they have. They certainly have, because there's lots of decisions that undermine this. It's inconsistent with like everything else. So yeah, it's bad law. Well, Justice Powell's dual-track theory of incorporation was already foreclosed in 1972. Well, even if it wasn't foreclosed, it's inconsistent with everything else, and for no particularly good reason. Some at this time argued it might play a role outside the realm of criminal procedure, including in, for example, Heller, where this exact point was argued and again rejected. Since then, the court has held otherwise. Until recently, dual-track incorporation tried at least a measure of support in dissent, but now is roundly rejected. Yeah, there have been some musings as to this, but no one believes in this anymore. Yeah. Nor has the plurality's rejection of Sixth Amendment historically unanimity requirement aged more gracefully. As we've seen in recent years since Apodaca, this court has spoken inconsistently about its meaning, but nonetheless referenced its traditional unanimity requirement on at least 8 occasions. In light of all this, calling Apodaca an outlier would be too suggestive of the possibility of company. Now, that's pretty funny. In light of this, calling it an outlier would be too suggestive of company. So that's a nice little burn, right? If we called it an outlier, that might suggest that there are other cases like it that it's outlier. But even the term outlier doesn't suggest how off the beat this is. I like that. Yeah. If we called it an outlier, it might suggest that there's some company out there. But no, this is way far gone. So even the term outlier isn't extreme enough. I like that line. It's nice. And I have to agree, it's not consistent with anything else. That's true. When it comes to reliance interests, it's notable that neither Louisiana nor Oregon claims anything like prospective economic, regulatory, or social disruption litigants seeking to preserve precedent usually invoke reliance interests. No one, it seems, has signed a contract, entered a marriage, purchased a home, or opened a business based on the expectation of a 10-2 verdict. That does make sense. Nor has anyone suggested that non-unanimous verdicts have become part of our national culture. It'd be quite surprising if they had, given that non-unanimous verdicts are sufficient to convict in 48 states and federal court. Instead, the only reliance interests that might be ascertained fall into 2 categories. The first concerns the fact that Louisiana and Oregon may need to retry defendants convicted of felonies by unanimous verdicts whose cases are still pending on direct appeal. Dissent claims this fact supplies the winning argument for retaining it, because it's generated enormous reliance interest, and overturning the case would provide a crushing tsunami of follow-on litigation. The overstatement may be forgiven as intended for dramatic effect, but prior convictions in only 2 states are possibly affected. Those states credibly claim the number of non-unanimous felony convictions still in direct appeal are somewhat in the hundreds, and rely on plea bargaining in these cases which will surely impose a cost. But new rules of criminal procedure usually do, often affecting numbers of pending cases. For example, after Booker versus United States held the federal sentencing guidelines must be advisory, this court vacated and remanded 800 decisions. Very good. Yeah. Similarly, consequences likely followed when Crawford versus Washington overturned prior interpretations of the Confrontation Clause, or Arizona versus Gant changed the law for searches. Our decision here promises to cause less disruption, and certainly nothing before us supports the dissent's surmise will cause wildly more disruption in our decisions. Yeah, that's all good. And we're in B2, so we're now in non-majority opinion. So this is not good law. So that was good law, this is not good law. Or it might be, depending on Justice Thomas, but we don't know that's good law because we got 4 votes for this. The second and related reliance interest in dissent seizes upon the interest of Louisiana and Oregon having security of final judgments. In light of our decision to say, the dissent worries defendants whose appeal are already complete might seek to challenge their non-unanimous convictions through collateral habeas review. But again, that worry outstrips the facts. Under Teague versus Lane, newly recognized rule of criminal procedure do not normally apply in collateral review, which is when it's not on direct appeal. Right? So anything that's not direct appeal is collateral review. So someone bringing a case outside of the normal appellate change, which would be for like most cases that are final, right? So does this apply to old convictions is basically what we're talking about right now. True, Teague left open the possibility of an exception for watershed rules, implicating fundamental fairness and accuracy of trial. But as this language suggests, Teague's test is demanding one, so much so that this court has yet to announce a new rule of criminal procedure capable of meeting it. And the test is demanding by design, expressly calibrated to address the reliance interest having the finality of criminal judgments. Okay, so the way I'm reading this is anyone whose appeals, normal direct appeals, are exhausted is just out of luck. So anyone who has been convicted non-unanimously, who has already exhausted all their appeals, too bad, so sad. So that's the way that they're putting this genie in the bottle. So this only applies to criminal cases that are ongoing. So, yeah, okay. This is non-binding though. So I suppose all this is dicta. So someone is still going to raise the question. I guarantee you. What there's a question as to whether or not this has retroactive effect. It seems to suggest no, and no is probably the better effect. But someone's going to bring this issue. So, nor is the Teague question before us. It isn't today. It will be someday, I'm sure. Whether the right to unanimity applies to cases on collateral review is a question for future cases, when parties will have a chance to brief the issue and will benefit from adversarial presentation. That litigation is sure to come. Yeah. And will rightfully take into account the state's interest in the finality of criminal convictions. So yeah. People whose direct appeals are over are absolutely going to try to do this, and we'll figure it out later. Okay. In this way, Teague frees us to know what we are. In this way, Teague frees us to say what we know to be true about the rights of the accused on the Constitution today, while leaving questions about reliance, possession, and final judgments for later proceedings. It would be hard to make sense to ignore that two-step process and count the reliance interest in the final judgment both here and again there. Certainly, the dissent cites no authority for such double counting. Yeah, what we do going forward and what we do retroactively are potentially two different issues. And so we can make a new rule going forward without making a new rule going backwards. Fair enough. Instead, the dissent suggests that feeble reliance interests it identifies should get a boost because the right to unanimous jury trial has little practical importance going forward. Okay. In the sense telling, Louisiana has abolished the non-unanimous verdicts, and Oregon seemed to be on the verge of doing so until the court intervened. Fair enough, but, whatever. But as the dissent itself concedes, a ruling for Louisiana would invite other states to relax their own unanimity requirements. Yeah. In fact, 14 jurisdictions have already told us they'd like to value the right to experiment with the non-unanimous juries. Yeah, I bet they would. Besides, Louisiana's law bears only prospective effect. So the state continues to allow non-unanimous verdicts for crimes committed before 2019. So yeah, there's crimes that would still be within the statute of limitations. So this would apply to those going forward. Anywhere with a person's finality of verdict is not done. While the dissent speculates that our grant of certiorari contributed to the failure of legal reforms, its citation does not support the surmise. No doubt, too, those who risk being subjected to non-unanimous juries in Louisiana and Oregon today and elsewhere tomorrow would dispute the suggestion that they're of little practical importance. Yeah. That point suggests another. In the valiant search for reliant interest, the dissent somehow misses maybe the most important one. The reliance interests of American people. Taking its word, the dissent would have us discard a Sixth Amendment right in perpetuity rather than ask two states to retry a slice of their prior criminal cases. Where that slice turns out to be large or small, it cannot outweigh the interest we all share in preservation of our constitutionally promised liberties. Indeed, the dissent can cite no case in which the one-time need to retry defendants has ever been sufficient to infer a constitutional right forever. Fair enough. In the final accounting, the dissent stare decisis argument rounds to zero. We have an immediately mistaken decision on constitutional outlier, an outlier on the day it was decided that's become lonelier with time. In arguing otherwise, the dissent must elide the reliance of the American people place in constitutionally protected liberties, overplay the competing interests of two states, count some of those interests twice, and makes no small amount of precedent all on its own. And we have section 5, which is also non-precedent because we got 4 members of the court. So this is also non-precedential. On what ground would anyone have us leave Mr. Ramos in prison for the rest of his life? Not a single member of this court is prepared to say Louisiana secured his conviction constitutionally under the Sixth Amendment. No one before suggests the error was harmless. Louisiana does not claim its precedent commands affirmation. In the end, the best anyone can seem to muster against Mr. Ramos is that if we dare to admit in his case what we already know to be true, what that might be said to be said in some others. But where's the justice in that? Fair point. Every judge must learn to live with the fact that he or she will make some mistakes. It comes with the territory. But something else entirely to perpetuate something we all know to be wrong because we fear the consequences of being right. That's very true. The judgment of the Court of Appeals is reversed. Very good. All right. Justice Sotomayor concurring separately. Now, she already joined all the opinions. So let me just double check. Yeah. So I already have her written down for every section except for A. So this is providing no additional votes for anything, but it is providing an argument with a rationale or a different argument. I agree with most of the court's rationale, and I join all but 4A. I write separately, however, to underscore 3 points. First, overruling precedent is not only warranted but compelled. Second, the interests at stake far more clearly than the outcome in those of recent cases. And finally, racial-based origins are uniquely matter here. I don't know that they uniquely matter, and I would tend to probably I don't know if I would mention it if it were coming to me or not, but it doesn't uniquely matter because I can decide the issue somewhere else. I don't need to go into the racial origins. They're very disturbing, but ultimately I'm looking to the original understanding, and if all that original understanding was the way that the court said it is, then let's just do that. That's what you're supposed to do. The Constitution means what is written. So if a jury trial is unanimous, then racial origins are additionally disturbing, but I don't need them to decide the case. The majority dissent rightfully emphasized stare decisis has been a fundamental part of our jurisprudence. We generally adhere to prior decisions, even when questioning their soundness, because to do so provokes even-handedness, predictability, and consequential development, fosters reliance, and contributes to actual and perceived integrity. But put simply, this is not a case where we cast aside precedent simply because the majority now disagrees with it. Yeah. Rather, Apodaca versus Oregon was on shaky ground from the start. It's not because of the functionalist analysis of the court's plurality. Reasonable minds have disagreed over time and continue to disagree about the best mode of interpretation, which, is not functionalist for me, it's originalist, but fine. Let the plurality in Apodaca use a different interpretation is not reason on its own to discard precedent. It might be for me, but we're not there. What matters instead is the majority rightly stresses Apodaca is a universe of one. An opinion uniquely irreconcilable is just not one, but two strands of constitutional precedent, established both before and after. The court has long recognized the Sixth Amendment requires unanimity. 5 justices in Apodaca itself disagree with the plurality's contrary view, just as Powell's theory of dual track incorporation fares no better. He recognized this argument on that score came late in the day. Moreover, the force of stare decisis as its nadir, which is the lowest point. Very cool. In cases concerning criminal procedure rules that implicate fundamental constitutional protections. I'm not sure whether it says nadir or not, but any constitutional issue, it's suspect because, yeah. And the constitutional protection here ranks among the most essential: the right to put the state to its burden, and jury trial that comports with the Sixth Amendment before facing criminal punishment. Where the state's power to imprison those like Ramos rests on an erroneous interpretation, the court should not hesitate to reconsider its precedent. Yeah, I'm okay with all this. In contrast to the criminal procedure context, considerations in favor of stare decisis are at their acme, which is another way of saying the highest. Very cool. In cases involving propriety and contract rights. Despite that fact, the court has recently overruled precedent where the court shift threatens vast regulatory schemes. That's true. This case, by contrast, threatens no broad upheaval of private economic interests, particularly when compared to the interests of private parties who have structured their affairs in reliance on decisions. The state's interests here avoid a modest number of retrials, emphasized at such length as dissent, and are much less weighty. They're certainly not new. Opinions that force change in criminal procedures typically impose these costs. And were the court to take the dissent's approach, defending criminal procedures' opinion as wrong, and Apodaca simply to avoid burning the system, it never correct criminal jurisprudence at all. Yeah, fair enough. The fact that we might have to redo some cases is kind of neither here nor there. It is what it is. The Sixth Amendment provides some guarantees. Those people are entitled to those constitutional guarantees. So, let's give them what the Constitution requires, right? To pick up on the majority's point, in the alternative universe, a trial judge alone could decide critical facts necessary to sentence a defendant to death. Overruled. Yeah. An officer would still be able to search a car upon the arrest of any one of its recent occupants. And states could still deprive a defendant of right to confront the accuser so long as the incriminating statement was releasable. So they're basically pointing out like other criminal jurisprudence cases that have overturned precedent and for the right? So if you apply this logic, like all these other things would still apply, and these are all garbage. They are garbage. So let's overturn this garbage too. That's fine. The Constitution demands more than the continued use of flawed procedure, all because the court fears the consequences of changing course. Yeah. Finally, the majority vividly describes the legacies of racism that generated the laws. Although Ramus does not bring an equal protection challenge, the history is worthy of the court's attention. Yeah, I don't know that you can really get to equal protection from the defendant's point of view. But it is, but the racist history does bar some consideration. That's not simply because the legacy exists in the first place. Unfortunately, many laws and policies have had some history of racial animus, but also because the state legislatures never truly grappled with the law's storied history in reenacting them. Where a law is otherwise untethered to racial bias, and perhaps also where a legislature actually confronts a law tawdry past and reenacting it, the new law may be free of discriminatory taint. That cannot be said of these laws. While dissent points to legitimate reasons for the reenactment, Louisiana's perhaps only effort to contend with the law's discriminatory purpose was when the law was repealed altogether. Together, Louisiana and Oregon's laws are fully and rightly relegated to the dustbin of history. And so too is Apodaca. While overruling precedent must be rare, this court should not shy away from correcting errors of the right to avoid imprisonment pursuant to unconstitutional procedures hangs in the balance. Yeah, I have no particular objection to this from Sotomayor. This is all good. This is all fine. I have no particular objection to this. Justice Kavanaugh concurring in part. So I have him down for every part of the majority. So, okay. In Apodaca versus Oregon, this court held state juries need not be unanimous to convict. Two states, Louisiana and Oregon, have continued to use non-unanimous juries. Today, the court overrules Apodaca and holds that state juries must be unanimous in order to convict. I agree with the court that the time has come to overrule Apodaca. I therefore join... Apparently I have become a Sotomayor fan recently. I'm not sure. I agree with the time has become to overrule Apodaca. I therefore join the introduction in parts 1, 2, whatever. I explain my view as to how stare decisis applies. Okay. The legal doctrine of stare decisis derives from the Latin phrase stare decisis et non quieta morere, which means to stand by the thing decided and not disturb the calm. The doctrine reflects respect for accumulated wisdom of judges who have previously tried to solve the same problem. In 1765, Blackstone, the preeminent authority on English law, wrote that it is established rule to abide by precedent, to keep the scale of justice even and steady, and not liable to waver with every new judge's opinion. The framers of our Constitution understood the doctrine of stare decisis as part of judicial power and rooted in Article 3 of the Constitution. Writing in Federalist 78, Alexander Hamilton emphasized the importance of stare decisis. To avoid an arbitrary discretion in the courts is indispensable. Federal judges should be bound by strict rules and precedent, which serve to define and point out their duty in every particular case. In the words of the Chief Justice, stare decisis' greatest purpose is to serve a constitutional idea, the rule of law. Fair enough. We all want to know what the rules are. Stare decisis does promote that, right? The court has repeatedly explained that stare decisis promotes even-handed, predictable, consistent development of legal principles, fosters reliance, and contributes to actual and perceived integrity. The doctrine permits society to presume that bedrock principles are founded in law rather than the proclivities of individuals. Yeah, we don't want every new member of the judiciary who comes along to change the law. That's that just puts it in the cult of personality. So we want something to be based in law, and so this is an anchoring principle that helps to do that. Makes sense. The doctrine of stare decisis does not, of course, mean the court should never overrule precedent. All justices now agree that it's sometimes appropriate for the court to overrule erroneous decisions. Indeed, in the last few terms, every current member of the court has voted to overrule multiple constitutional precedents. Okay, fair enough. Historically, moreover, some of the court's more notable and consequential decisions have entailed overruling precedent. Yes, there have, and there's a whole long list of them. The lengthy and extraordinary list of landmark cases that overrule precedent includes the single most important and greatest decision in the court history, Brown versus Board, which repudiated separate but equal of Plessy versus Ferguson. Fair enough. It was a very notable opinion for a lot of reasons. As these many examples demonstrate, the doctrine of stare decisis does not dictate, and no one seriously maintains the court should never overrule precedent. As the court has often stated and repeats today, stare decisis is not inexorable. On the other hand, as Justice Jackson explained, just because someone should voice Celia is no reason for crashing into Carbitus. I assume that's like a reference to Homer's Odyssey or something. So no one advocates the court should always overrule erroneous precedent. That's fair enough. Rather, applying the doctrine of stare decisis, the court ordinarily adheres to precedent, but sometimes overrules precedent. The difficult question then is when to overrule. To begin with, the court's precedent on precedent distinguishes statutory from constitutional cases. In statutory cases, stare decisis is comparatively strict, as history shows, and the court has often stated. That's because Congress and the President can alter the statutory precedent. To be sure, enacting new legislation requires finding room in a crowded legislative docket and securing agreement of both the House, the Senate, and the President. Both by design and a matter of fact, enacting new legislation is difficult, and far more difficult than the court's cases sometimes seem to assume. Nonetheless, the court has ordinarily left the updating of correction of erroneous statutory precedent to the legislative process, because Congress can always change the law. That's fine. The principle that it's more important the applicable rule be settled than it be settled right is commonly true, even where the error is manifest serious concern, provided correction can be had by legislation. In constitutional cases, by contrast, the court has repeatedly states again today, the doctrine of stare decisis is not as inflexible. The reason is straightforward. As Justice O'Connor once wrote for the court, stare decisis is non-strict when we can interpret the Constitution because our interpretation can be altered only by constitutional amendment or by overruling our own prior decisions. The court therefore must balance the importance of having constitutional questions decided against the importance of having them decided right. It follows that in unusual circumstances where fidelity to a particular precedent does more to damage the constitutional ideal than advance it, we must be more than willing to depart from that precedent. In the canonical opinion of Burnett, Justice Brandeis has described the court's practice with respect to stare decisis in constitutional cases as a way that was accurate then and remains accurate today. In cases involving the federal constitution, when corrected through legislation action is practically impossible, this court has often overruled earlier decisions. That said, in constitutional as statutory cases, to overrule an important precedent is serious business. In constitutional as in statutory cases, adherence to precedent is the norm. To overrule a constitutional decision, the court's precedent on precedent still requires special justification. In particular, to overrule precedent, the court requires something over and above the belief the precedent was wrongly decided. Justice Scalia put it, the doctrine of stare decisis always requires reasons that go beyond mere demonstration that overruled opinion was wrong, for otherwise the doctrine would be no doctrine at all. At least in constitutional cases, maybe. To overrule the court demands special justification or strong grounds. But the special justification or strong grounds formulation elicits a key question. What constitutes special justification or strong grounds? In other words, deciding whether to overrule an erroneous constitutional decision, how does the court know when to overrule and when to stand pat? As this court has exercised the judicial power over time, the court has identified various stare decisis factors. In articulating and applying those factors, the court has, to borrow from James Madison's words, sought to liquidate and ascertain the meaning of Article 3 judicial power. Stare decisis factors identified by this court in the past include the quality of precedent's reasoning, the precedent's consistency and coherence with previous or subsequent decisions, changes in the law since prior decision, changes in facts since prior decision, the workability of precedent, the reliance interests of those who have relied on it, and the age of the precedent. Fair enough. But the court has articulated and applied those various individual factors without establishing any consistent methodology or roadmap for how to analyze the factors together. In my view, that model poses a problem for the rule of law, as this court attempts to apply stare decisis principles in a neutral and consistent manner. Yeah, there's no way to weight them, and so if you can pick from them in any degree you want, then there's no anchor to it, right? As I read the court's case on precedent, those varied and somewhat elastic stare decisis factors fold into three broad considerations that, in my view, can help guide the inquiry and help determine what constitutes a special justification or strong ground. First, is a prior decision not just wrong, but grievously or egregiously wrong? A garden variety error or disagreement does not sufficient to overrule. In the view of the court that is considering whether to overrule, the precedent must be egregiously wrong as a matter of law in order for the court to overrule it. In conducting that inquiry, the court must examine the quality of the precedent's reasoning, consistency, and coherence with other decisions, changing law, changing facts, workability, among other factors. A case may be egregiously wrong when decided, see, for example, Korematsu or Plessy, or may be unmasked as egregiously wrong based on later legal or factual understandings, see Nevada versus Hall, which I'm not particularly familiar with that case. Second, has the prior decision caused significant negative jurisprudence or real-world consequences? In conducting that inquiry, the court may consider the jurisprudential consequences, some of which are already relevant to the first inquiry, such as workability, as well as consistency and coherence. Importantly, the court may also scrutinize the precedent's real-world effects on citizens, not just the effects on the law and legal system. Third, would overruling the precedent decision unduly upset reliance? This consideration focuses on legitimate expectation of those who have reasonably relied on the precedent. In conducting that inquiry, the court may examine a variety of reliance interests and the age of the precedent. In short, the first consideration requires inquiry into how wrong the precedent is. A second and third together demand, in Justice Jackson's words, a sober appraisal of disadvantages of the invitation, as well as those of the question case, owing the practical offense of one against the other. Thank you, Matt. Those three considerations together provide a structural methodology and roadmap for determining whether to overrule an erroneous constitutional precedent. The three considerations correspond to the court's historical practice and encompass a variety of individual factors the court has applied over the years as part of the stare decisis calculus, and they're consistent with the founding's understanding. And for example, Blackhand's shorthanded description that overruling is warranted when, and only when, a precedent is manifestly absurd or unjust. Taken together, those three considerations set a high, but not insurmountable bar for overruling precedent, and therefore limit the number of overrulings and maintain a stability in the law. Those three considerations also constrain judicial discretion in deciding whether to overturn a erroneous precedent. To be sure, applying those considerations is not purely mechanical exercise. I do not claim otherwise. I only suggest that these considerations may be better structured on how to consider the many traditional stare decisis factors. It is inevitable that judges will, of good faith, apply stare decisis considerations that sometimes disagree about when to overrule, as the court does in this case. To begin with, the judges may disagree about what the prior decision was wrong in the first place. Importantly, that disagreement is sometimes the real dispute when judges joust over stare decisis. Yeah, they're disputing as to whether it's wrong. But even when they decide that it's wrong, they may disagree about whether the decision is so egregiously wrong as to justify a ruling. Judges may likewise disagree about the severity of the jurisprudential or real-world consequences caused by the erroneous decision, and therefore whether the decision is worth overruling. In that regard, some justices may think the negative consequences can be addressed by narrowing precedent, rather than outright ruling with it. Justices may also disagree about the measure of relevant reliance interests that affect those in the overruling. On top of all that, judges may also disagree about how to weigh and balance all those competing considerations in a given case. This case illustrates the point. No member of the court contends the result in Apodaca is correct. But members of the court very vehemently disagree about whether to overrule. I'm not sure really why. I mean, to me, it seems pretty clear we should overrule it. I mean, it's a decision that is not in keeping with any other precedent. It's proved problematic. I don't see any particular reason to maintain it. So, assuming we get that far, I look forward to the dissent telling me why we should maintain it. Because it's a very strange thing to try to maintain. Applying three broad stare decisis considerations in this case, I agree with the court's decision to overrule. First, it's egregiously wrong. The original meaning establishes that the Sixth Amendment requires unanimous jury. An original meaning of the court precedent establishes the 14th Amendment incorporates the Sixth Amendment. When Apodaca was decided, it was already an outlier, and it's becoming even more outlier. The original meaning of the 14th Amendment overwhelmingly demonstrates it's egregiously wrong. It causes significant negative consequences. It's true it's workable, but Apodaca sanctions the conviction of trial or guilty plea by some defendants who might not be convicted under the proper rule. The consequences traditionally supplied some support for overruling egregiously wrong criminal procedure precedent. In addition, and significantly to the analysis of this case, the origins and effects of non-unanimous jury rule strongly support overruling. Louisiana achieved statehood in 1812, although through most of the 1800s, the state required unanimous juries. Interesting. But in 1898, the Constitutional Convention, the Louisiana enshrined non-unanimous. Why change? State wanted to dismiss the influence of black jurors. The convention approved non-unanimous juries as one pillar of a comprehensive and brutal program of racist Jim Crow measures against African Americans, especially in voting and jury service. In In light of the racist origin of the non-unanimous juries, it's no surprise that non-unanimous juries can be different in practice, especially in cases involving black defendants, victims, or jurors. After all, that was the whole point. And the method has not changed. Then and now, non-unanimous juries can silence and negate the vote of black jurors, especially the case with black jurors, defendants, or victims, and only 1 or 2 black jurors. 10 jurors can simply ignore the views of their fellow panel members. That racial bias can undermine confidence and respect for the system. Okay, that's all good. Skip a little bit. To be clear, one could advocate for and justify non-unanimous jury rule by resort to neutral and legitimate principles. England has appointed non-unanimous juries, and various legal organizations in the United States have a time champion legal non-unanimous juries. Louisiana's moderate policy decision to retain non-unanimous juries as a decision distinct from its original decision may have been motivated by neutral principles or inertia. But the question at this point is not whether the Constitution prohibits non-unanimous juries. It does. Rather, the disputed question is whether it to overrule unanimous an erroneous precedent that allow for non-unanimous juries. On that question, the question is whether to overrule the Jim Crow origins of racial discriminatory effects on non-unanimous juries should matter. I mean, I could decide this issue without resort to them, but I think going to like the motives of the people that pass, I think it matters. I just don't think it's necessary to dispose of the case, but it's fine. To state the point in simple terms, why stick to an erroneous precedent that's egregiously wrong? It's American constitutional law that allows convictions of some would not be convicted and reinforces a practice that's thoroughly racist in origins and has continued discriminatory effects. That's fair. Overruling the case would not upset Reliance. Only Louisiana and Oregon employ these non-unanimous juries. Court decision today will validate some convictions where the issue is preserved, but a consequence always ensues when criminal precedent is overruled. Except for the fact of the limited class of direct review cases, it will be relatively easy for them to abide. Okay. Moreover, the court applies separate non-retroactive doctrine to mitigate the defect. On court precedent, new controversial rules apply in direct review, but do not apply retroactively on habeas corpus. And there's some exceptions. There's some stuff going on with Teague and the exceptions. So assuming the court faithfully applies Teague, today's decision will not retroactively apply and not disturb convictions that are final. Well, that's the decision for another day for sure. All right, Justice Thomas concurring. Is the chat still with me? I haven't seen any chat in a while. Are you guys bored? Do you not want any more? I agree with the court. Okay, this is Justice Thomas concurring. I agree with the court that Petitioner Ramos' felony conviction for non-unanimous was unconstitutional. I write separately because I resolved this case based on the long-standing view of Sixth Amendment includes protections against non-unanimous guilty verdicts. I also made clear this right applies against the states through privileges and immunities clause. Way to go, Justice Thomas. Trying to breathe life into that baby. Justice Thomas trying to overrule slaughterhouse cases, man. Doing God's work as far as I'm concerned. I begin with the parties' dispute is where a Sixth Amendment includes protection. Last question, I do not write a blank slate. Our decisions are long recognized. Blah, blah, blah. Some history, repeatedly reaffirmed. Questions are entitled to stare decisis. As I previously explained, the court's typical formulation of stare decisis does not comport with our judicial duty because it elevates demonstrably erroneous decisions over the text. Yeah, so Justice Thomas is not a huge fan of stare decisis. Because our precedents are thus not outside the realm of permissible interpretation, I will apply them. So we got some stuff dealing with Blackstone. Considerable evidence understanding persistent until the 14th Amendment. Going through some history stuff. Courts based on this evidence, the court's prior interpretation is not demonstrably erroneous. It's within the realm of permissible interpretation to say the trial by unanimous includes a protection against non-unanimous felony verdicts. So he thinks it's not demonstrably erroneous. He thinks it's a possible interpretation in light of the history. Interesting. The main question is whether the right is protected against states. In my view, the Privileges or Immunities Clause provides the protection. I do not adhere to this court's decision applying due process incorporation, including Apodaca, as seems this court opinion in this case. The Privileges or Immunities Clause states that no state shall make or enforce any law which shall abridge the privileges or immunities of the United States. At the time of the 14th Amendment, the terms privileges or immunities have established meaning as that of rights. The court, however, has made the Due Process Clause serve the function the Privileges or Immunities Clause should serve. Although the Privileges or Immunities Clause granted United States citizens a certain collection of rights attributable to that status, the court has interpreted it quite narrowly. Perhaps to compensate for this limited view, it has incorporated through the Due Process Clause. Yes. Due process incorporation is demonstrably erroneous. Justice Thomas is right. So the privileges or immunities is a much better mechanism than substantive due process. Substantive due process doesn't make sense. I'm not sure how much difference it would make, though, in the end, but he's right. It's more philosophically pure. I decline to apply the legal fiction of due process of corporation. As a result, I part with ways both the court on its affirmative argument of the 14th Amendment and its treatment, which 5 justices agree. I would accept prisoner's invitation to decide the case on privilege or immunity. The court conspicuously avoids saying which clauses it analyzes. When one is assumed from silence, is ear following our due process incorporated precedent, I believe nothing in this case turns upon that. I've already rejected our due process incorporation as demonstrably erroneous, and I fundamentally disagree with applying the theory simply because it reaches the same result. Close enough for horseshoes and hand grenades, not constitutional interpretation. Very cute, Justice Thomas. Very good. The textual difference between protecting citizens and persons will surely be relevant in another case. That's a fair point, too. That's a fair point. Okay, so he concurs in the judgment. All right, so now we got some dissent from Alito, Roberts, and Kagan. And yeah, all right. So I guess we call this 6-3. We'll call this a 6-3 decision. Let's see what the dissent has to say. The doctrine of stare decisis gets rough treatment in today's decision. Lowering the bar for overruling our precedent, a badly fractured majority sets aside an important and long-established decision with little regard to enormous reliance it has engaged. The majority's approach is not a just way to dispose of this one case. The decision marks an important turn. Nearly half a century ago in Apodaca, the court held the Sixth Amendment permits non-unanimous verdicts in state criminal trials. All the years since then, no justice even hinted that Apodaca should be reconsidered. Understandably thinking Apodaca was good law, the state courts in Louisiana and Oregon have tried thousands of cases, but today the court does away with it, and doing so imposes a potentially crushing burden. The court, however, brushed aside its consequences, even suggests the states should have known better than to count on our decision. To add insult to injury, the court charged Louisiana and Oregon with charges of racism for permitting non-unanimous verdicts, even though the court found such verdicts to be constitutional, even though their entirely legitimate arguments rely on them. I would not overrule Apodaca. Interesting. Who's writing this again? Alito? Okay. Whatever one may think about the correctness of the decision is enlisted enormous and entirely reasonable reliance. Before this court's decision intervened, the decision appeared to have little practical importance going forward. Louisiana has now abolished it, and Oregon seems on the verge of doing so. Too much public discourse today is sullied by ad hominem rhetoric. That is attempts to discredit an argument, not by proving it's unsound, by attacking the character or motives. The majority regardlessly succumbs to trend. At the start of the opinion, the majority asked the rhetorical question: why does Louisiana and Oregon allow this? Racism, white supremacy, and Ku Klux Klan. Non-unanimous verdicts, the court implies, are part Jim Crow. If Louisiana and Oregon originally adopted these laws for these reasons, is deplorable. What does that have to do with the broad constitutional questions before us? The answer is nothing. I mean, even under rational basis review, you need like a non-arbitrary and non-capricious reason, and you could make a credible argument that these motives fall into the arbitrary and capricious example. Like it goes into like mixed motives, right? Like the same result could have two different reasons when they're legal and when they're illegal. The same action can be legal and illegal. You know, the motives of the person doing it may be relevant. And so here too, it's like it may be relevant. So, you know, I don't quite agree with that. For one thing, whenever the reasons why Louisiana and Oregon adopted the rules, both states readopted the rules under different circumstances. Louisiana Constitutional Convention of 1874 adopted a new narrow rule, and its stated purpose was efficiency. The people of Louisiana ratified the new Constitution. The majority makes no effort to show the delegates retain the rule for discriminatory purposes. The same is true for all the Oregon revisions and reenactments. The most important point, however, is today's decision is not limited to anything in particular. The court holds the Sixth Amendment requires unanimity in all criminal trials. If at some point a state won't allow non-unanimous verdicts, today's decision will rule that out, even if all the state lawmakers are angels. Yeah, but you still have to get to the originalism issue, right? So like, okay, if you want to say like the motives are irrelevant, okay, that's fine. Then it becomes a question of is it within the bounds of a legitimate policy choice of a government, state, federal government? Is it within the bounds of a legitimate policy choice? And to answer that question, you'd say, well, does the Sixth Amendment allow for either one? You know, if the Sixth Amendment allows for either one, then either one is fine, assuming all the other standard things apply. You know, rational basis and all the rest of it. But again, going to originalism issues, to me, it seems like, given the precedent in history that we're talking about, that the originalism would seem to counsel that this is not within the scope of a legislature's choice. So, you know, the fact that they're all angels and want to do it for completely great reasons, if it's not within the scope of their authority, then what does it matter? So, for these reasons, the origins of the rules have no broad history on the Constitution. It might be relevant, though legitimate reasons. Okay, some years ago, British Parliament enacted rules. Okay, so we're going to talk about the fact whether they're racist or not, and there might be legitimate rules. Okay, Justice Blackleaf will concede the point that there are legitimate arguments for it, you know, in terms of a lot of different rationales. But the question in my mind is the originalist understanding, right? If there are legitimate reasons to do it and legitimate people can do it, then you go into like some sort of rational basis, intermediate scrutiny, strict scrutiny analysis, whatever. And it's depending on the situation. So, you know, if this were a choir of angels doing it for a choir of angel reasons, it still doesn't answer the question of if it's within their power. So, like, okay, you want to ignore the racism issue and simply say, well, they could do it for good reasons. Okay, well, can they do it for good reasons? That's the question, right? I begin with the question of whether Apodaca is precedent. It's remarkable it's even necessary to address this. But in Part 4A of the principal opinion, which does not have 5 votes, 3 justices take the position was never precedent. The only truly fitting response to this argument is really. I agree with that. Consider what it would mean if it was never precedent. I mean, the entire legal profession was full for 84 years, or 48 years. Believing there was precedent, the courts tried thousands of cases under the rules. But according to 3 justices, this court were deluded. This court, for example, held, I read that earlier. It's like, is Justice Jackson's opinion the guiding one? I'm like, yeah. So, like, okay, so I agree with you. I agree with you there's a precedent. You know, I don't think it's right. I don't think it's originalist, but I think Justice Jackson's is the controlling opinion. You know, This court, for example, apparently helped to perpetuate the illusion. Okay. Quoting a whole bunch of cases citing Apodaca. So, sure, Apodaca was good law. Justice Jackson's opinion was controlling. It allowed for this two-track approach, but the opinion is crap. Let's overrule it. It's not originalist. So if you want to ignore all that stuff and say legitimate reasons, then fine. But all right. So Apodaca is precedent. So he's bitching. Alito's bitching that at the three people who said it's not precedent, it's precedent. Following Marx is precedent. I mean, he's bitching at three people who say it's not precedent and not controlling. I'm like, yes, it is. Following Marx, it is. So, like I said this when I analyzed the three people who said it. I said doesn't make any sense. Just the least controlling opinion is the one that controls. Two-track approach. It's not consistent with anything else. So it's precedent. It's just bad precedent. Let's overturn it. Okay, so we want to ignore racism. Okay, fine. They've adopted. There's a whole bunch of examples where people have adopted this on other places for non-racist reasons, and even if it was racist at the start, it's not racist now because they changed the rationale. Fine. All right, it's not racist under its current formulation. Fine. And I even said this when I analyzed it earlier. Like the racism, I was like, it's not really doing that much for me, right? It's fine. He wants to ignore that. That's fine. That's cool. I don't really care that much. He wants to say it's precedent. Yeah, that's cool. It's precedent. That's cool. But why should we maintain it? All right, let's get into that. Under unreasonable standing, it's precedent. It is precedent. Okay. Decision prescribed. Yeah, blah blah blah. It's precedent. Okay, controls precedent. Blah blah blah. It's precedent. That's fine. What's what our colleagues say? They suggest it's not precedent. I don't care. It's precedent. It's trust. Yeah, they try to argue it's not. It is. The Marx rule is controversial, and 2 terms ago, I said it was last term. It was 2 terms ago. I was close, but yes. But we ultimately left it rule and left it intact. Yes, you did. Yeah, that's fine. Yeah, as long as the rule stands, it refutes the argument it's not binding because the majority not can agree on a rationale. Yes, I agree. Marx suggests that one opinion is controlling. I'm totally on board. His 3 opinions contend that treating it as precedent required to embrace. Okay, blah blah blah. I don't care. Okay, all right. Initial question then is whether, in a case where there's no opinion, the position taken by a single justice can constitute a binding rule. Under Marx, the clear answer to this question is yes. I agree with that. Logic and Marx apply equally no matter the division. I agree to that. And we're of no case holding as applicable. Yes, I agree to that. The dissent has correctly interpreted Marx as far as I'm concerned. The dissent has correctly interpreted Marx. The one person opinion is controlling. I'm on board with that. And no one in any of the opinions that we read suggested what the controlling opinion is otherwise. No one suggested, no, this is the controlling opinion. No one suggested an alternative. So yeah, I'm on board with it. It's a controlling opinion. That's great. The next question is whether the rule applies indifferently to precedent that was established through fraction decision. Yeah, no, it doesn't apply any differently. It's precedent just like anything else. I'm fine. The final question is whether Justice Powell's reasoning, namely his view the 14th Amendment did not incorporate every aspect of the 16th Amendment, is binding. And the answer to the question is no. One of the years after new questions arose about the scope, as did, no one thought for a second that it can admit the court. That's fine. I don't really care either way. All right. For these reasons, Apodaca is clearly precedent, and the court wishes to be done with it. It must explain why it's consistent with the doctrine of stare decisis. Yeah, well, I can almost do that in my sleep. It's proven unworkable. It's been undermined by the decisions. It's it's not super hard. I mean, it's a complex question, but we looked at some of the reasons why you'd overturn precedent, and we can overturn it. It's fine. You want to have a reason to maintain it other than you don't think it is. All right, stare decisis is important. It's not inexorable. Should have a body of neutral precedents. The doctrine should be transformed into a tool. That's fine. What is the majority's doctrine for overruling? No apparent appreciation for irony. It's divided. Today's majority, which is divided into 4 separate camps, decries the majority's deeply fractured. That is a bit of irony, yes. The majority's primary reason is that it's supposed to poor quality. Yeah, that too, and in fact, and it's also inconsistent. The majority indicts Justice White's opinion of okay, it's White, not Jackson, as I said earlier, but no, Powell. I'm sorry. The majority indicts White's opinion on 5 grounds. Spent almost time grappling with it. Did not give due weight. Did not give account. Looked at function. Agreed a breezy cost benefit analysis, which is fine because the court was really flippant and not really considerate, or kind of blew by the relevant issues, is one of the reasons I don't consider Miller to be a good precedent. I mean, it is good precedent, but if you ask me personally, do I think U.S. v. Miller is good precedent? Not particularly. Why? Because it's just poorly reasoned. It's not well argued. It basically tries to do the issue, rule, analysis, and conclusion all in one paragraph. It just really doesn't, and it's very muddled, and it wasn't well argued. It's just not a very good decision. So you know they want to blow, the majority wants to blow by Apodaca for essentially the same reasons I want to blow by Miller. It just that it just kind of is crap. The reasoning is kind of crap. It's just not a very well written opinion. It's not well reasoned, not well argued. So all that stuff, that's fine. That's a reasonably good reason. Looking at the quality of it, looking at the quality and looking how well it was argued, and looking how well it's briefed, and looking how well it was reasoned, I think is reasonable. So if an opinion is particularly shit, we can look past it. And he says Justice White, it's unfair to look at White because he already done so earlier. That's fair. I mean, if he had already done so thoroughly in another opinion, there's not necessarily any reason to do it again, right? So if you've already done all that analysis in an earlier opinion, you can just take it as given that you've said it. So that's fine. It's unfair to criticize White for not discussing a prior decision of comment and jury. None of the decisions went beyond saying it was a feature of common law right, or cursorily stating that unanimity was required. Well, and Williams had already decided to not preserve all aspects of the common law right. Well, Williams is wrong. Don't care about the racism issue. It's hard to know about the functionalist charge. Okay. Functionalist criticism dodges the naughty problem. No one questions the Sixth Amendment incorporate the core of the common law to incorporate every feature. The constitutionally require there are 12 jurors, even no one can say why 12 is a magic number. That's a fair question. It's still an open question, incidentally. To incorporate features that we now know to be highly objectionable, such as the exclusion of women. Fair question. There are arguably other rationales for looking past that issue, but it's a recent one. If the right to a jury means what it meant at the time, and it was all meant at the time, then you could read it that way too. But then you could also look at it a little bit more broadly. Of course, it was all property owners at the time, right? So things have changed a little bit in that respect. Yeah. So unless one is willing to freeze in place 18th century practices, next to incorporate distinguished features that incorporating those or not. To look to the opinion, look to the underlying purpose. Majority describes as functionalist, provides no alternative. Did not claim the Sixth Amendment incorporate every feature of the common law practice. Did it not? Did the majority? Someone else asked. Tell me, is this correct in your opinion? Because I don't think this is correct. The majority does not claim the Sixth Amendment incorporate every feature of the common law practice. Did they claim that did or did not? Because I don't quite think that's a fair characterization of the majority's opinion. But it does not identify any practice for identifying the features. On the question of jury service, the majority alliance is buried in a footnote. Exclusion of women was outlawed by further constitutional amendments, presumably the 14th. Does that mean that the majority disagrees with Taylor? Another opinion served Justice White, the exclusion of jurors violates the Sixth Amendment. That's a good question. That's a good question, actually, because if it doesn't violate that's a good question. I never really thought about it. But yeah, that would be an interesting question. Does the exclusion of women violate the Sixth Amendment? It's an interesting question. I guess it depends a little bit on what you view as the nature of who has to sit on a jury at the time, right? So it's all men, property owners, and is that still a limitation today in an originalist interpretation? That's a pretty good question, actually. That's a pretty good question, actually. And what about equal protection, and how does that impact the analysis? Is it that there's a non-trivial originalist question to be had there, all right? If like the right to a jury at the time of the adoption of the Sixth Amendment was all male property owners, then what is the rationale for saying that women must be on juries as far as the Sixth Amendment is concerned? It's a good question, actually. It's a pretty good question. It's a pretty good question. 19th gives women the right to vote. I don't think the 19th Amendment has anything to do with the Sixth Amendment. I'm not sure that women. Well, then again, no, because if you view it as people who have suffrage, if the question is the Sixth Amendment gives the right to anyone who has suffrage, so maybe that's the right way. Maybe Matt has the right point. Maybe the way to look at the Sixth Amendment is anyone who has suffrage, because I think it's correct that in 1791, like the only people who had suffrage were male property owners. So maybe the issue is like the jury is anyone who has suffrage. So the 19th Amendment maybe does answer that question because women now have suffrage under the 18th under the 19th Amendment. So maybe Matt, yeah, maybe that's the right way to look at it. The Sixth Amendment extends to anyone who has suffrage, and then the question is who does have suffrage. So, and you can modify that with later amendments. Matt has a good idea. I like it. That's a good idea. That's a good idea. Yeah, I like that idea. Yeah, that's a good idea. Yeah. Yeah. Incidentally, nobody who says your rights have not been well, okay. Um, Nobody says it's either a violation of your rights if a woman's on your jury or not. Well, under the current case law, the issue isn't whether or not your jury has women or men or white people or black people. It's not an issue of what the jury composition ultimately is. It's an issue of the jury pool and the ways that people are excluded from the jury pool to be on the petite jury. So if through lawful means and if through the circumstances of chance, because when you're pulling people from, we usually use like voting records or DMV records or something, but if it so happens that your pool is such that when you're ultimately done, you wind up with all white men, then that's not constitutional violation. No, it just has to be a fair chance that it has to be. So like you look to the mechanisms on how the jury is selected. And the issue is that you're not excluding anyone because of protected characteristics from the pool. So the issue isn't the ultimate composition of the jury. The issue is the composition of the jury pool. And then you get into grounds to which people from the pool can or cannot be selected. But so it's a little bit different than to say, just because you have all white men in the jury doesn't make it unconstitutional. You look to the pool and you look to the mechanisms by which people got on the pool to the petite jury. So, and we're looking to an impartial jury. So we have to do this in an impartial way. And if we're looking to all people that have suffrage, then you don't want to discriminate against people who have suffrage in a non-impartial way, right? So if we do it based on some characteristic and it just so happens to be that we wind up with a skewed jury, that's constitutional. The question is the impartiality from which we constituted the jury pool and the impartiality from which the pool was then narrowed down to the petite jury that sits. So, but looking at suffrage does help to solve the issue. So Matt has a pretty good idea. Yeah, equality of outcome versus equality of opportunity is another way of looking at it, right? So yeah, you're not looking to the outcome; you're looking to the opportunity. That's a reasonable way of recharacterizing it. Yes. But yeah, it's not the issue of what the jury pool is, but how it came to be. Yes. So nobody asked. So if there's a hypothetical municipal court where it's effectively an all-white male jurist pool, it's unconstitutional if you're not white male and you want a juror just like no, absolutely not. No, a jury has to be comprised of a jury of your peers, right? So you look to what is a peer, right? And the way we're interpreting this, and Matt has provided the suggestion, and I think it's a pretty good one, is we're looking to everyone that has suffrage, everyone who has the right to vote. So your peers are everyone who has the right to vote. So those are the peers. And we're looking to do it from everyone. So it is not a constitutional violation if you're of one race and the jury is of a completely different race. It's not a violation if you're of one sex and the jury is of a completely different sex. The question is that everyone who is eligible to be in the pool had an equal probability in the pool, and if the lotto dice are such that you wind up with an all-white jury and you're black or vice versa, then it's not a constitutional violation, no. So you're looking to the bias in the process, not the result. So that's good. Yeah. Well, felons are not in many states. Felons do not have franchise. They don't have the right to vote, so they do not consider it a peer. They're not part because the peers. Again, if you think about what it is, right? You think about the society. Society is being represented on that jury pool, right? It's the people of New York versus whatever, the people whatever. So it's the society that is creating the laws. So whether or not felons should be in the pool or not, but like if you exclude them from the pool, there's no constitutional violation, because those people have proven themselves not to be part of the polity, or not enough to be part of the polity to be excluded from the consideration of this important function. So they have that reduced role. So yeah, that I like your suggestion though, that we can look to it as an issue of who does have and who does not have franchise. So that solves that problem. So that we look to, well, it's just that what we've changed is who has franchise, and we've changed it through the 19th Amendment, we changed it through the 26th Amendment, and changed it through some other things. So 13th Amendment. So we've changed who has franchise. Yeah, I like that. So I like that answer a lot, man. That makes a lot of sense. So the question is, the 6th Amendment established who has franchise, and who had franchise changed in the 13th Amendment, changed in the 19th Amendment, changed in the 26th Amendment. So we're still interpreting the 6th Amendment as everyone who has franchise. It's just that the nature of that has changed through some other amendments. I think Matt has the right answer. This is a good answer, Matt. Very good. Props for you. Very good, Matt. Very nice answer. Yeah. Fifth, it's not accurate to say Justice White based on conclusion cost-benefit requiring jury unanimity. His point was the court had already identified fundamental purpose. I cannot say I would have agreed with him if I sat in the court, but the majority's harsh criticism was unwarranted. Maybe. Yeah. What about the Powell's concurrence? The majority treats Powell's views idiosyncratic, but does not merit decision. Justice Powell's belief constitutional law states a degree of flexibility in interpretation of certain constitutional rights, though it's not a dominant approach. Only gradually to the court abandon two-tier system, yes. But I don't really even have like an objection to like arguing that like maybe this wasn't the only second-tier case. Like if you want to argue there were other cases that did a two-tier thing, if you want to argue like it was more gradual or something like that, I'm totally cool with that. Like I'm still just on board with, it's unconstitutional now. Like, it just doesn't flow from what we have. Again, I think the other cases, the other parts of the opinion we read had much more persuasive authority in it. We look to these guidelines as guidelines, and they're not particularly well constrained because they still get a lot of flexibility and still like you can come out with the result you want. But I don't really think that this is like quite that kind of situation, because I think the majority has it right that this is pretty much an outlier of an outlier. This is really off the board, and it's been undermined before and after, and been undermined by the case law, been undermined by the precedent, been undermined by the common law, all that crap, right? So and it's proven unworkable. It's undermined. It's like, so it's just bad precedent. I don't quite see why Alito is going to such effort to keep this precedent. I don't quite understand it, because it just seems like garbage. Like, even if you want to argue like it was more of a gradual thing and not quite like as sharp as the majority agrees with, I mean, at least as it exists today, it's sharp. I mean, there's no other thing today that I'm aware of that has a two-tier. You know, it's either incorporate or not. So there's no two-tier today. That doesn't make quite sense, right? Even now, our cases do not hold every provision applies in the same way the federal government states. Okay. A notable exception is the grand jury clause, a provision like the Sixth Amendment reflects the importance of the founding generation attached to juries. Yes, but the difference there versus Apodaca is the grand jury clause has not been incorporated. It is non-incorporated. So it's not that it's been incorporated in some lesser form. It's not two-track, right? It's just that it's not incorporated. Now, whether or not it should be incorporated, right? If you want to argue the non-incorporation doctrine for grand juries is wrong in light of other things, I think there's a case to be made there. But it is a distinct thing, right? Because there's some things that are non-incorporated, not very many of them. This is one of them. And some things that are incorporated, like basically everything. This is non-incorporated. If you want to argue that decision is wrong, I think you can get there. But it's not quite the same category, no. Because it's just non-incorporated. Some states have grand juries, but they don't have to. And it's up to them how to use them if they do. So the court held in and this is an 1884 decision, which also suggests like it's a little crap. Because I kind of think like, I've said before, like anything before like 1930s is kind of crap. So like this is an 1884 decision. So like, yeah, it might be crap. So maybe that should be overruled too. You know, I haven't really thought about it that hard in terms of whether or not it should be incorporated or not, but maybe it should be overruled. You know, I don't know. But it's a different question. It's not the same question. So they held that the grand jury clause is not by the states, and they made a substitute preliminary hearing. Okay, decision based on reason, that's not easy to distinguish. It's a slightly different thing, and maybe we should go back and re-examine that. That's fine. You know, and again, like the idea that maybe they're both wrong. Maybe we should re-examine that. I don't know. You know, I haven't really spent a lot of time thinking about it. I haven't read that case. I'm not sure I've ever read that case. So maybe it's wrong. Maybe we should incorporate it. I don't know. But like the rest of the Sixth Amendment has been incorporated, right? And like even in Apodaca, it was incorporated. So even in Apodaca, it was incorporated. It was just kind of incorporated halfway. The halfway thing is crap. So either make it non-incorporated or incorporated, right? The half pregnant thing is not working. Yeah. That case remains good law is critically important to 28 states that allow them to be prosecuted. If we took the same approach, the whole in that case could be called into question. Okay. I mean, I have no particular objection to calling into question. I mean, again, I don't know that I've ever read that case. I don't know the degree to which it's consistent with the other subsequent cases. I mean, I'd have to go through the analytical reasoning. But maybe it is crap. It could be crap. The majority's only other reason for overruling is inconsistent with related decision and related development, which, you know, again, going to O'Connor's argument is a pretty good reason to look at this. I agree with Powell's views on incorporation is not in harmony. Majority's point about recent legal development is an exaggeration. No subsequent Sixth Amendment decision has undercut the plurality. Ooh, that is the wrong argument. That's a straw man argument, my friend. That's straw man. It's not that a Sixth Amendment case has undercut the plurality. That's straw manning. It's weakening the argument. It's that the entirety of all the incorporation cases, all of them have undermined this. So yeah, maybe there's no Sixth Amendment subsequent that's undercut that. That may be true. I don't know that's true, but I'll take your word for it. There's no subsequent Sixth Amendment case that's undercut that plurality. I'll take your word for it. That's true. There's been a shit ton of other cases and other amendments that have undercut it, though. So that's straw man argument. Oh, that's not what the majority's talking about. They're not talking about the Sixth Amendment exclusive case law is somehow the thing that governs this. That's bullshit. Now, that's not the argument. It's not like, oh, because the rest of the Sixth Amendment interpretation since then has changed it, we should change this part of the Sixth Amendment interpretation. No, that's bullshit. That's not what the majority is talking about. They're talking about like all the other stuff, including, for example, and not, the Second Amendment and Heller and McDonald. Like, how about the subsequent Second Amendment decisions that have undercut that plurality? How about that? How about that? Maybe we want to talk about Heller and McDonald and how that's undermined it. Oh, we want to limit this to the Sixth Amendment. Oh no, that's just straw manning bullshit right there. Yeah, that's no good. And whilst Justice Powell's view on incorporation has been further isolated in later cases holding two additional provisions apply with full force, like I just said, shit. The prospect of complete incorporation was nearly done with Apodaca was headed down. My mind is blown. It's blown. It's completely blown. This is not working for me on any level. No, this is crap. Well, the majority worries that Apodaca is inconsistent with her cases. Yeah, a little bit. Jesus Christ. It's a little inconsistent, yeah. Majority ignores something far more important. Really? The way in which Apodaca is intertwined with our body's Sixth Amendment case law. How is it intertwined? How is this pulling the thread? Okay. As I explained, the plurality reasoning was based on some fundamental mode of assumption, which held just 2 years earlier, did not constitutionalize the common law's requirement jury as 12 members. Fair. That's a fair point. The 12-member jury thing is still up in the air. And some states use 6-member juries, like particularly for like low-level misdemeanors. And like the federal rules of criminal procedure only require 11. And so the 12-member thing is a thing that is still like in the open. And maybe we should re-examine that. Maybe it's the case that like juries, I don't know the common law that well, Jesus. But maybe it was the case that like even for misdemeanor cases, even for like they were always require 12-member jurors. So maybe they should all require 12-member jurors. I don't know. If you're asking me as an originalist, I want to know like, okay, under what circumstances was a 12-member jury required originally in the common law? Was it like all criminal trials? Was that the rule? Misdemeanors, felonies, all of it? And like, okay, and if that's the rule, then let's go do that. So yeah, maybe we should say 12-member juries are required. I don't know. It's a reasonable question, but we could go into the history of it. And if you ask me as an originalist, I'd want to know, okay, what's the history? What's the history? There have been some quotes we've definitely seen from some people like Blackstone that suggest strongly 12-people juries were required. So maybe it was required. Maybe we should require 12-person juries. I don't know. But, if you ask me as originalist, let's go do that. Yeah. That's fine. Only one state now permits non-unanimous. May more allow 6-person juries. That's true. There's a footnote. And they cite to Arizona and Utah and Florida, which I think talks about like misdemeanors and stuff. And maybe those have to go too. I don't know. If you ask me as a Supreme Court justice, I want to know, well, what is the history? And I'm sure you're going to brief me on it. And then I want to know what's the originalism. So maybe we should require 12-person juries. I don't know. And as for why 12 in particular, well, it doesn't really matter. Maybe it's just an accident of fate. But if that was like what the well-established like standard was at the time of the founding, and like everyone knew that juries always had 12, even if 12 is a historical accident, well, whatever. It's a historical accident that was adopted. Why 12? I don't know. Okay, if that was what we were doing at the time, then cause works as a perfectly reasonable analysis. That's what everyone knew what we were referring to, so let's do 12. Great. That's fine. Repudiating Apodaca will almost certainly prompt calls to overturn Williams, which deals with the 12 members. Yeah, again, I have no particular objection to consideration to overturn Williams. I don't know whether or not Williams is right. I don't know history that well. I don't know it that well to know whether or not Williams should be overturned or not. I don't know. But if, it was used in misdemeanor and felony trials and like for 400 years and blah, 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 then like, yeah, let's overturn Williams too. Williams was wrong. That's cool. I'm down for that. If that's what it should be, that's what it should be. Let's do that. That's cool. Up to this point, I've discussed the majority's reasons for overruling, but that's only half the picture. What convinced me should be retained are the enormous reliance. For 48 years, They've conducted thousands and thousands of trials. None of them face a tsunami of litigation. At a minimum, all defendants whose cases are still in direct appeal will presumably be entitled to new trials if they are convicted by a less unanimous jury and preserve the issue. Fair enough. And so be it. That's part of the deal. If they're convicted of non-unanimous juries and they preserve the issues and their case is still ongoing, then, so be it. At least in Oregon, if even no objection was voiced, the defendant may be able to challenge the convictions on plain error. Okay, I don't know well enough to know for sure, but sure. Oregon asserts that more than 1,000 defendants whose cases may be able to challenge their convictions. We'll have to deal with it. The state has also reports that defendants are arguing that the instruction allowing for non-unanimous verdicts is a structural error that requires reversal of all convictions in those who are not polled or for which the jury was unanimous. Well, I bet they are arguing that. But, I don't necessarily know that that's going to get you anywhere. No. Unimpressed by these potential consequences, the majority notes we vacated or remanded nearly 800 decisions for resentencing after United States versus Booker. But the burdens of resentencing cannot be compared with the burden of retrying. And while resentencing was possible in all the cases, no guarantee that all the cases can be retried. In some cases, key witnesses may not be available. It remains to be seen where the criminal justice system have resources to handle the volume of cases. Then you might be getting into the issues of whether or not prior testimony can be read in, which gets into due process issues. But they still had counsel and they still had they were sworn in and testimony was offered. So you might be able to read in old testimony just because and let the jury consider old testimony. So you might be able to do that. I don't know. That's going to be an interesting question, I'm sure. These reviews on direct appeal are only beginning. Prisoners whose direct appeals have ended have argued it allow them to challenge it. Yes, they will. The claim succeeds. The courts will be overwhelmed. Quite possibly, but, we'll see. The majority's response to this is evasive. It begins by hinting that it will not apply a collateral view on the framework of Teague. Under Teague, an old rule applies both in direct and collateral review, but if today's decision constitutes a new procedural rule, plaintiffs will be able to rely on a collateral proceeding only if we turn a watershed rule. That's fundamental fairness and accuracy. Noting that we've never found a new rule to be watershed, the court hence that this decision is likely to meet the same phase. But having feigned in this direction, the court quickly changes course. Say, application of today's decision, appeals should not concern us. That question, we're told, will decide in our case. Yeah, there's no reason to decide what's not before you, too. There's that. The majority cannot have it both ways. They really, really can, because the Supreme Court typically does not rule on issues not before it. The Supreme Court does not really hypothesize, no. As long as retroactive remains a possibility, crushing burn on this one will not be ignored. Yeah, but that's what the lower courts are for. That's what the lower courts and courts of appeals are for, so we don't have to figure it out. You guys go figure it out, fight about it for a while. While Schritt's court has been chary in recognizing new martial rules, no means clear that it will preclude application. Teague only applies to new rules, and the position taken may lead to the conclusion the rule announced is an old rule. Taking that position, 3 members that was never precedent. I don't know that's quite what they said, but, whatever. Thus, if Apodaca were never precedent, it may be argued today's decision not oppose a new rule, merely recognize what a correct rule is. Yeah, I'm sure they will. Yeah. 2 other justices of majority acknowledge this precedent must be pursued as regarded as new rule, blah, blah, blah. So they're arguing about the consequences. I don't care. The majority of the consequences express no view, nor should they, because there's no reason to decide it. Whatever the ultimate reason, the issue is not only here as concrete, deal. In reaching the conclusion, I do not disregard the interests of petitioner. And again, you're not really dealing with the stuff going forward either. You want to maintain this rule because of these reliance interests? Bullshit, no. The plight of defendants is important and cannot be overlooked. Apparently you're overlooking a little bit. But alone cannot be dispositive. Otherwise, stare decisis will never apply in criminal convictions. You're overstating your case, Alito. You're overstating your case. The Reliance outserts the rule, blah, blah, blah. And franchise, we're talking about some other stuff we're talking about some other cases we overruled with Reliance interests. Talk about Citizens United. We're talking about Janus. I don't care. Striking out precedent. It should not be overruled. Okay, well, that's the end of that. That's great. All right. So we've reached the end of the case, thank God. That was 87 pages of wonderful analysis and insight, and it's gotten much darker here. So yeah, I think the majority has it essentially right. I think that Alito kind of has it wrong. I think Thomas has it right. But whatever. And they can deal with the consequences of it. So that's all good. So that took us 3 hours to go through that. Well, it's a lot of fun. It's a lot of fun. If you liked this stream, I would appreciate, as always, if you'd be so kind as to give it a like. I really do appreciate your support and your continued participation here. I really appreciate that you are here to join me. And I found it was a very intellectually challenging case. It required a lot of thought, it required a lot of consideration. But I think the majority has it right. None of the opinions contradicted the history. For me, it's pretty important, right? Because we're looking to what did the clause mean at the time. So we looked to the English common law, we looked to the 400 years of history, we looked to all these things that were adopted, and it meant unanimity, right? So, like, if you take an originalist approach, as I do, and you say, well, what did the text mean at the time? It talks about juries and everything that came with it, including unanimity, possibly 12-member juries. That's another question for another day. So, like, for me, no one contradicted the history of it, so it seemed all pretty good. I don't know where you go for notifications of live streams, to be honest. Nowhere in particular. I don't announce them like anywhere except on YouTube, so I don't know what to do. Favorite sitting justice? Who's my favorite sitting justice? That's a good question. I'd probably say Gorsuch is my favorite. $5 from oh, did Wisconsin file did Wisconsin file something in the COVID case? I have not seen Wisconsin's reply. I have not seen Wisconsin's reply in that. Should we go through that for a little bit? Dogbert, can you the initial filing? What initial filing? The initial filing was from the student, the kid. There was no initial filing from Wisconsin. I mean, I thought if you're asking how much did I enjoy the pleading, I thought it was very well written. I thought it was very good, and it like attached all the exhibits. Right, there's like not a lot of dispute over facts because like, well, here's all the original exhibits. It's like, oh, the police did this. How do we know? It said so in their filings. Oh, it's like, how do we know that the administrator did this? Because they said this in this email. It's like, it's like, So I look forward to whatever Wisconsin is gonna respond. I assume that their response is going to be a lot of qualified immunity, and we'll see how that goes. But yeah, it's pretty much a travesty. Yeah, I don't really know why the case is the way it is, but it is what it is. All right. So, anyways, thank you all for being here. I'm going to end the stream. I think I'm going to get some Chinese food tonight. Till later, my friends. Cheers. Goodbye.